Yes.
May it please, your lordship. In item number 17, lordship, lower court records are available. That may be tampered.
17. Yes.
Yes.
What?
Lower court records are available. That may be tampered.
Oh, obviously, it will be taken.
It is not shown in the cause list.
As not shown in the
The
Once you requisition the rent.
requisition is required, lordship, from the
ঠিক আছে। Requisition
obliged lord.
I'm praying for listing of this IAM for correction of your lordship's order. Your lordship, while granting bail, has made it subject to the satisfaction of the district and session judge, my lord, which would be additional session judge. my lord. So that may be not tomorrow, my lord. I'm obliged.
May I please, your lordship. My lord, yesterday I have filed one additional affidavit, my lord, in item number 46 of today's supplementary list, my lord.
46.
46 of supplementary list, my lord. So, my lord, that is not, so that may come, my lord.
46. Item number 46. You have already filed?
I have already filed yesterday, my lord, so
Additional?
that may come on.
Okay, we'll call. We call for.
May I please, your lordship, with respect to item number 41, it's a pre-arrest application.
Hmm.
There's a three petitioner, the accused number 1 has been arrested. So if the liberty may be granted for filing bail application.
You are at liberty what to do. Why should I give her liberty?
The AB is already pending and the CD is here.
Yes.
So if meanwhile, if that
You
may
are
be,
at liberty. We no need to pass any kind of order. So when the 41 will be called up, then you make your submission. And apart from that, there is no need of any liberty. You are at liberty. You are at liberty always to file your bail application. There should not be any order passed by this court at least. Okay, that petition for number one may be infructuous
yes,
in regards to AB.
yes.
Rest he is at liberty.
I
You call for the record, then you submit your submission.
know.
Yes.
My declaration of this opinion revision petition 2023. It's twice listed before this honorable court, but not reached my lord.
Court number 11. Make a mention before court number 11. Make a mention before court number 11.
I've gone through the notice. Your lordship also taken up criminal revision petition.
Make a mention before court number 11, senior bench.
What?
Please, yeah, please, your lordship. I beg to mention item number 30, lordship.
30.
30. Kindly pass over a matter for the day.
We have not received the CD, lordship.
CD not received. Are you on interim?
Yes, lordship.
You are on
Yes,
interim?
lordship.
Yes, that's when it can be. CD not received. Issue reminder.
On 28 May, lordship.
28 May. 28/5, we are listing. Your interim will be extended till 20.
CD may be called for. In the meantime, notice may issue upon the victim father,
No, respond number 2 is who? Who is
father of the victim.
he lost the FIR?
No, lordship, no. The FIR was SI Police Ranjan Moni Matsang.
SI.
SI.
Then you have to make this amendment and you have to make a party there. Otherwise, how can we send? You can make the father of the victim as a respondent number 3. That can be done. Okay. Because no, who is there? Muhammad Amar Ali?
Muhammad Umar Ali,
It will case design.
the victim.
Muhammad Umar Ali is the
Amir Amar Ali.
Amar Ali.
Muhammad
Father-
Amar Ali is the father of the. So you have the father of the deceased.
Victim is a 15 years old boy. Lordship, he
Victim died.
died.
Oh, he died. Achha, achha.
Lordship, may kindly Berus page 13.
Oh,
Mary.
then to okay. Oh, 306 is there.
Lordship.
Depends he subsequently committed suicide.
Lordship. Lordship, actually, date of incident was 6/12/2022. And the FIR was on 24/2/2023 after receiving the postmortem report. Upon the management committee of madrasa, but I am not the management committee. I am a teacher of the madrasa, Faith madrasa.
Cause of death is there, Lordship.
Hmm? Hmm?
During investigation, I have received the PM report, Lordship.
Oh, yes, yes. Date was due to asphyxia as a result of anti-mortem hanging. Injury report presents. Well, on anal canal was anti-mortem and due to forceful penetration, however, this is a sent for. Then you cannot make the victim of the father. I won't allow you. It's a case only for being one madrasa only. So this response number 2, who is response number 2? Father of the
Father
victim.
of the
So you have already made party father of the victim. You can, SI police says you can represent the, not represent, he is not made party in fact. On what basis you made party the father of the victim here?
Lordship, as per notification.
But the fact of the case is otherwise, in fact. He may be managed. Do you know? The father has already been managed. That's the case. It's a case against madrasa, where he was sexually exploited and had to not commit suicide, most probably it may be murder also. That is the case. Okay, you can issue notice against the response number 2, but that won't help you. Response number 2 registered into notice COVID. I will call for the case diary. Through the judicial police station to the office of the registry and the public prosecutor. So do you want to, the informant should be also made party here, or otherwise state can represent? Okay then. When it can be fixed?
It's 14, Lordship, on 22nd, Lordship,
22nd will reach the, I will get the CD
from Bongaigaon, Lordship.
from Bongaigaon.
Or
Can it be on
Lordship,
20?
then fix it on 23, Lordship, you can try.
I don't know, 22nd or 23. There are lots of matters already been fixed. That's why just keep it fine. Many matters are there on place 29 only. Oh. 29 fine. You take steps today only. Item 12. Yes.
Although this is a case, my lord, this regarding this unregulated deposit scheme.
Mm.
Now you will also kindly see the FIR matter. This petitioner, he is a salaried employee of that company. He has nothing to do with the board or nothing to do with the company affairs, my lord. Now you will also kindly see the FIR. His name is also indirectly has come. Page, you will also kindly see page 12. Page 12. With due respect, I beg to state that I am a poor lady. I have heard from the villagers about a new source of money earning scheme. I, along with our neighbors Halima and Manjuma Khatun, went to the institution, namely Support India Development Program located at so-and-so, and came to know that for joining, it is required to provide details of Aadhaar card, fill up the membership form. If anybody take membership by paying rupees 2,000 as joining fee, then she will get opportunity to make 30 malas. And by depositing the same, she will get 300 every week. And if anybody take membership by paying rupees 3,000 as joining fee, then she will get opportunity to make 40 malas, and by depositing the same, she will get rupees so and so every week. On 8 to 25, I have taken membership of the said company. You know, kindly note that is very important, my lord. Because I joined the company on, my lord, 1/1/25. My joining is 1/1/25. And I resign on 27/1/25. That's why date is important, my. Now you will kindly see, I have taken the membership of the said company, that is 8 to 25. And after my joining, they provided one mixer machine as gift and also provided one packet material for making 40 malas. They also intimated that they will pay rupees 100 to me against newly joining member. And if I am able to join 40 members, then I will become the leader of the group and every month I will receive rupees 4,000. After getting the above information, I took initiative to join 14 women in the company. I have come to know about the persons who have opened the company, namely Rashidul, I am number one, Rashidul. Mumin Islam and one Akram Hussain Lashkar of West Bengal. And I met the above said persons in the office. There are some other persons in the office except the above said person. As a poor woman and seeing the way of earning, I joined the company and also took initiative to join some other women. But some of them have not received the materials from the company till today, and the accused person delaying the matter by taking date. It is a matter of regret that on 22/2/25, I was no longer there, my lord. The police personnel raided the house of the company and arrested Akram Hussain Lashkar of West Bengal and seized the documents of the company. I have come to know that the said company is a fraud company. Today, on 23/2/25, I have come to know about the details of company that the above said company has opened the office near our village without any documents and with an intention to cheat the poor women, then collected money by giving false assurance in the name of the source of income and misappropriate the same. I have come to know that there are many people are involved in the scam. Now kindly see your lordship, page 21. This is my appointment or authorization, my lord. I was allowed. This is order dated 1st January 25. Your lordship will find first, but immediately after my name, my lord. To whom it may concern, this letter service is formal authorization for Support India program to act as social activities of marketing. This authorization is granted with full confidence and authority to represent our interest in this matter, effective from 1st January. Your monthly salary is rupees 10,000 per month. Then you also these things is there that Support India Limited, some kept no more. Here, these are the my consulting room numbers, and that is the. And your lordship kindly say page 29, last page, my lord. Page 29. My resignation also, because I met an accident, I have given the prescription also, my lord. And because of the accident, I resigned from that unit. That originally page 30, my lord. They have received the copy which will be there. With due respect, I beg to state that I so and so have been working as a marketing officer in your Support India. But it is a matter of regret that on 26/1/25, I met a bike accident at so-and-so road and received grievous injuries on my legs and hands. Therefore, you wanna kindly accept my resignation letter and thus apply. Next page, my receipt is there, signature is there. So I was there only for a period of hardly 3 weeks. 3 weeks, about 4 weeks, my. And during this period, my lord, I had nothing to do, my lord. Because the period they are saying, and I am salaried person. Basically, my lord, I am not part of the management. Unemployed person, my lord, once they get it, they also get elevated, my lord, and rejoin.
There is one notice.
Heard Mr. H.I. Chaudhary, learned senior advocate, assisted by Mr. M. Mondal. The learned counsel for the petitioner. I also heard Mr. MS Andas, the learned additional PP appearing on behalf of said respondent. This is an application, the section so and so in connection with so and so. Next right is submitted by Mr. Chaudhary that the present accused petitioner is innocent and he is no way involved in the alleged offense. It is a fact that he joined in the company, namely Support India Development Program, as a salaried employee, and but when he made an accident on 26/1/2025, for which he had to give his resignation before the company. Thus, he worked in the company only for 3 weeks, and he has no way connected with any, no way connected as alleged in the FIR. No, he has not committed any such offense as alleged in the FIR. However, he is ready and willing to appear before the done it before the investigating officer and to cooperate in the further investigation of this case if he is released on bail. No, if he is granted the privilege of pre-arrest bail. বাকিখিনি কৰি দিব তেখেতক allow কৰি দিব. He insisted to call for the case diary. He will be under interim. Yes,
Obliged to lot. He will appear within
7 days.
7. Obliged.
On June, Lordship,
Yes, it can be
6th of June.
Obliged.
city.
May I please?
Yes,
A long affair lordship lodged by police officer, lordship will see the affair page 10,
each day.
lordship. I am reading lordship first paragraph. The Tamulpur PS case number lordship. With reference to the subject cited above, I would like to inform you that on 29/4/2025 at about 10:10 PM, confidential information regarding suspicious cyber-related activity at Salmora village at the house of Ziarul Khan, son of Nurul Haq Khan, at Tamulpur PS was received by the undersigned. Accordingly, police party headed by the undersigned left towards Salmora via Tamulpur PS GT number so and so. On reaching the house of Ziarul Khan, local witnesses were called, but due to late night, none of them agreed to come to witness the search. Accordingly, search in the house was made under videography and in presence of police witnesses. On entering the house, 8 numbers of suspected persons were found operating laptops, huge numbers of cell phones. On questioning, they could not provide any satisfactory answer as to what exact work they were performing. The following digital instrument and mobile were found used by them and seized. This is the also basic allegation the affair. The thing is that the Ziarul Khan, although also my name has been mentioned in the affair, Ziarul Khan, this property not belongs to me, lords. I have no way connected with the property where this alleged accident took place. So after lordship inquiry, I came to know that this property was gifted to my wife by her lordship paternal family. So since lordship we are staying at Guwahati, we lordship rented the land property at Tamulpur, which is far away from here lordship. We are no way connected with it. Now lordship the person one person lordship I have mentioned in the petition that's Along. He has lordship taken our property on lordship rental basis, monthly rental basis. He said that he will lordship run a business of wholesale fish in that area. Now lordship the police has lordship searching us that we are the owner of the house, so our lordship statement is necessary. So lordship this is not property of this petitioner. This property was gifted to my wife lordship by his by their lordship paternal family. So lordship, I may be lordship protected. I will appear and I will lordship thoroughly interrogate lordship cooperate with the investigation.
Lordship, allegations are serious.
Allegations are
Let
serious,
us
Lordship. I
take
also
calm,
agree,
Lordship.
yes. The allegation is
to
serious.
know after knowing his involvement, Lordship.
Yes.
Interim may be
But
granted, not at
property
this
belongs to
stage,
some other
Lordship.
person lordship. My name has been wrongly mentioned lordship in the affair.
And the city will call. City will call.
Some protection, I will show that I can cooperate with the police lordship.
Let us see, because you may not be involved there, your house may be I mean used for that
Yes,
purpose.
yes,
That
yes.
that is your submission, but prima facie it's a case of thing.
Materials are there lordship. I have seen the affair, but lordship the thing is that the property not belongs to me lordship. Although they have mentioned the affair that they reached the house of
Now,
Ziarul Khan.
suppose property is not belong to you, but
Yes.
if this betting is going on in your house, or whether is there any involvement from your side, that is to only to see.
Yes.
So we are listing it on, yes,
On
he is not in
26th,
interim,
26th,
23rd.
Twenty-
Okay, we are listing it on
26 lordship.
23rd.
2023
Yes,
lordship.
23rd.
But on that day lordship, even if city doesn't come, lordship will consider it as respect lordship. Obliged.
Standing 9. Can be.
May I plead lordship?
Yes.
482 application lordship. Bokista PS 151 under section 120B 419 420 468 471. The FI is page not 12.
12.
12 type copy. The FI it is the information is that his brother had a plot of land.
Informant's brother.
Informant's brother had a
Oh.
plot of land, and that has been purchased by the present petitioner through power of attorney. And this informant has brought an allegation that power of attorney was forged. But the landowner whose land belongs, he had not filed any FIR. The informant's brother, who is the original owner of the land, he has not filed any FIR. His brother has brought an allegation saying that this power play has been forged, and with this power play, I had sold the land, which is that is the allegation. Then this power of attorney, I have annexed the power of attorney. Page number 20 is the power of attorney. This through due process, your lordship. I had this here obtained this power of attorney, and this has been all annexed. Everything is done through a process here. And I am apprehending errors at this point of time. At this point of time, I may be protected, and so that I may appear before the investing officer and to produce all the relevant documents to prove that I have purchased those through power of attorney.
This statement will be recorded.
Hmm?
This statement will be recorded. CD is also and
His statement may be recorded.
appear before the IO and in the maintenance CD may be called. back.
Here, not only he forged his signature and also executed the sale deed, in fact.
CD is also.
This is the allegation brought by the brother, not the person who is
There may be some reasons brother is not in the picture now.
maybe.
I don't know.
So I may submit, I may give my statement before the investor, I may be appeared. I'll produce relevant documents. Till CD comes, I may be protected.
Going to tell, hard so and so for you. This is an application section so and so. Mr. Chetri, the learned counsel for the petitioner submitted in this regard that the present petitioner is innocent and he executed the sale deed, purchased the land. Your name is?
Rahul Mishra.
Rahul Mishra.
And purchased the land only on the strength of irrevocable power of attorney executed on his behalf by the brother of the informant. However, he is ready and willing to so and so for the work. In that context, Mr. Stilan additional PP submitted that statement may be recorded, the statement of the petitioner may be recorded and also insisted to call for the case diary. Interim DD. Okay, you'll be on the interim.
On
All right.
lordship, fixed on 6th of June, lordship.
6 is good.
Bail hearing, item 14.
But please, your lordship.
Please.
But please, your lordship. In this case, lordship, the 14 who is appearing.
And lordship, 1 year, 6 months, lordship in custody, lordship. But my avertment is lordship made, I have filed an additional affidavit, lordship, and at the time of filing lordship, I put the 10x lordship. That is on record, lordship. The
1
ground
year?
of 1 year, 6 months, lordship. And lordship, and ground of arrest, lordship, I have annexed with my additional affidavit, lordship, subsequently. And it's can be this. Lordship is there, lordship. So, lordship, ground of arrest, lordship, and will find lordship page number 34, lordship, in my affidavit, lordship. Under section 50, notice to the arrestee under section 50 of CRPC, case number so and so, petitioner name is so and so, and you are hereby, we got lordship, page number 20. And you are hereby informed that you have been arrested in connection with the above referred case after finding sufficient evidence against you and will be forwarded to the judicial custody. And next page, lordship, the arrest memo, lordship. And the reference case number so and so, name and address of the petitioner, name and police officer, so and signature of the relative, so and so, but there is nothing in ground of arrest is mentioned, lordship. And another lordship inspection memo, that is lordship, there is nothing, lordship. As per Bihan Kumar.
Otherwise, what is the stage of the case at present?
Lordship already, lordship, and
For evidence.
evidence system.
27-1 to
Evidence.
last order is of 27-1, therefore it is not updated.
Otherwise, lordship, the Bihan Kumar case and the probable purpose, the lordship is squarely covered me, lordship, but ground of arrest is, there is nothing, lordship. So 1 year, 6 months, lordship. May consider. And local man, lordship, from Guwahati. Permanent resident, lordship.
Yes, Goswami, he will mainly to the plea of not furnishing. Otherwise, cases of commercial quantity.
Okay, the commercial valid manner. Conscious police.
You are caught red-handed?
Lordship.
You are
No,
caught
lordship,
red-handed?
lordship, as per the FIR, lordship, from the rented house, lordship, in the rented premises, lordship. So not specifically from my possession in my, I am hold a bag or anything else in my pocket, nothing, lordship. That much is not there, only from the resident, rented house in the campus, lordship. That is the,
Submission, 1 year, 6 months. Huh? Evidence not yet recorded, not yet started, we hope. 50 CRPC, I said, huh? 50 CRPC. Not from conscious position of the present petition, that much is submission. And the rest, same. Mr. Goswami's submission is also same. Made from the conscious position. And
He's from the conscious one because from his house, my lord.
yes, from
the
his house.
FIR.
Yes,
It's clear, my lord.
from his rented premises.
Okay.
And apart from that, commercial quantity, rigor of so and so will come. And the submission will record that though there may not be any written communication, but oral communication
yes,
was there,
that-
he is
that-
not, he is aware about.
He is
the-
aware, but that much, man, he is aware of the.
Yes.
In the search sheet. Now the case is search sheeted, my lord.
Yes,
And he is also, my lord, engage his own lawyer, which is the object of the act, my lord.
yes, yes.
So by now, my lord, as these things will come, my lord, once, my lord, because
Obviously.
this may be according.
Your case is from which place?
Guwahati, Kamrup Metro.
Kamrup Metro.
Metro.
Special just Kamrup Metro. Okay.
Deeply obliged, lordship, obliged. 50. Sorry, lordship, item number 32, can it be a two, lordship?
Item number,
32, lordship, a two, lordship.
I cannot say. It will also
Give
matter.
time permit, lordship,
Maybe, we are not fixing any.
lordship, obliged, lordship.
My please.
Yes.
Commercial quantity lordship on the ground that lordship of notice lordship. And moreover, they are behind the bar for 1 year, 11 months, 26 days lordship.
1 year, 11 months.
26 days.
What is the stage of the case?
Stage lordship, PW's lordship, the 17 numbers of PW's is their lordship. And till the filing of the case, lordship, 4 PW's were examined.
4 PW's exam.
At the time of filing lordship. Now, meantime, lordship.
It will pass. From
5 PW's.
5 PW.
Five lordship. After filing of this, 1 PW. So altogether 17 PWs were there lordship. 2% are there lordship, though it is commercial. Now the ground has been taken lordship for notices lordship that I have filed a additional affidavit lordship.
Where in page number?
Regarding grounds, man, I have to argue a
Okay.
case, man, so it may be fixed on 20.
No, ground
Because-
problem and other part lordship that.
You want to
2
argue
years,
on
lordship.
that?
Yes, ma'am, because it is, might not be, my lord, covered by Bihan Kumar and others.
And regarding that lordship, long incarnation lordship, because it is 2 years lordship, only 5 witnesses has been examined out of 17 lordship.
If only matter merit matter, if he wants to merit matter, I
But
can
two
argue
grounds
on
are there,
merit matter.
lordship.
I can argue on merit today matter. If he take the other ground matter, then other thing. The merit was also matter, he is matter, the Caesar witnesses, your lordship will errors matter, he is implicated matter. Altogether 5 witnesses matter, so section 37 is squarely applicable here matter. And
Well, 12
So
witnesses
when
are
we want to fix it?
and lordship has fixed on those cases, some cases on 20.
Out of semi-fire? No.
No, matter, regarding some cases, lordship in the motion. matter.
Yesterday.
No, today, your lordship.
Or 22nd, 23rd, we are
Yes,
maximum we are
yes,
fixing.
yes, then
But lordship will not
If-
be here, lordship. Lordship will not be here, lordship. in
And
principle.
that is not the question. It will be some other women will be heard.
if the lordship dispose on merit manner, that is different thing, but their case manner.
Because otherwise disposal merit also you see 1 year. See now here, say around 6-7 months for the filing of the charges is required.
Yes.
And thereafter framing and charge, then
Yeah.
obviously 5 witnesses have examined, so we
so
cannot
it-
consider it the inordinate delay. in
inordinate
fact.
delay. Then
But he
cannot-
had brought some other reasons.
that
So
is-
on that count, if you
Yeah.
want to have some argument, then
Yes,
we'll
then-
hear it.
Yes, that is right.
Then 22nd, 23rd,
Not-
23rd, Paribana, 22nd or 25th. 22nd, we're listing it on 22nd. And the request made by the learned additional PP, Mr. Gusami, let the matter be listed on 22nd.
Second. 16 also lordship, same. Kuntu.
No, but 16, your position may be different, I don't know.
Yes,
He is,
There, lordship, notice.
he is on that, pardon?
Yes,
Notice, lord.
this case is different, ma'am.
Different, because he is on some other ways, on Pankaj Bansal, I think. So that is the issue, that's why he is going to argue, but your this one 16 may be different. That's
No,
what
the
I-
same commercial quantity, lordship.
No, commercial quantity is different. For your petition is behind the bar since when now?
This is lordship from. From lordship 9/4/2024
9/4.
or 9/4.
So your this one is different. You
Yes.
can make submission here.
24 lordship.
9/4/24.
Oh, lordship.
No, he is on post Pankaj Bansal, Pankaj Bansal is there. That's why he is different. He wants to argue on that only. But this is different. This is different. You can argue this. Yes.
On the notice lordship that additional affidavit has been filed.
You
lordship.
have already filed additional.
Lordship.
affidavit. Your petitioner's name is Sanoj.
Sonos Kumar Ray.
Sanoj Kumar Ray. So it is already charge sheeted, I think. Case is charge sheeted one.
Sasited.
There is a arrest memo. Apura, notice 50 CRPC. Juta dias. 48
Yes,
like. He is in custody since 9/4/2024. Case is charge sheeted. Trial had already been commenced already. Charge framed. Charge framed. Charge framed. Is there any witness examined till date?
Till the filing of the case lordship, no
No
one was
witnesses.
examined.
Is there any Gusami?
Another
9 listed witnesses are there. Lord.
How many? 9.
9. But
Nine
the
is-
filing of the case lordship, no one was examined.
9 listed witnesses.
Lordship kindly peruse the NCR. The last order.
Yes. He has already also filed this the 50 and arrest memo for Sanoj Kumar. Now, what is this stage? Is there any examination? No.
In the Because probably charges frame.
Yes, charges frame.
That's frame was saying.
Charges has already been framed.
There are charges framed on 22/10/21.
That I have annexed lordship on page
And my
44 lordship.
next date here, it is my 27/3/25 that has gone by for evidence.
Yes. So by that time, there may be one or two examination out of 9 witnesses. We are not in a position to say, but he is basically on the ground of most probably non-furnishing. Seventeen C matter, 17C. Submission to you. Section 50 CRPC as arrested on 9/4/2024. Charge filed. Charge has already been framed. Case is at the stage of evidence, but till date, no witnesses could be examined by the prosecution. Baki same thing. No, your conscious position is there
Yes.
from your for trade handed one. From where you're from vehicle or
No, from train lordship.
from train?
Lordship.
Acha. For trade handed train or that issue will be there. For trade-handed. We have Goswami, we have passed some orders in regards to court trade handed also.
Yes.
So from your side submission, Mr. Kaushik was there in that day. So there was some submissions. There are some the cases reference also. So we'll put these references of this. This is a case from this Kamrup Metro only.
Come.
Okay, then this is from Kamrup Metro, special just Kamrup Metro.
Because the quantity is very large.
Market.
Pardon?
4.08 kg opium. That is
Yes,
very
opium.
used.
Yes, yes, yes.
Yes.
Much obliged.
Made video laundry. Madam here.
We have
Can you-
received this scan copy, I think.
Here, I say,
I say no. But
We have
it is
received
not-
here?
Yes.
Okay, yes, we have received. Huh? This is connected with item 46. 46 up to, no?
I,
I say 46.
Have you gone through, Mr.?
No, because in 17 item, but there is no answer, my lord. I said it is not there.
We have received just now.
Yes, my lord.
That was a submission from in 46 on your behalf. Yes, yes. So we have received now. No, someone informed me that additional affidavit is here filed.
Yes, it already come.
Sometime you need or
Some time.
after some time.
Sometime means time for you. So that I may come.
sometimes,
आधा घंटा 15 minutes.
In the second half, or
Second half, bring it on, second half means 2. At 2 will do?
Is it
Okay, okay, body matters at 2.
at one is
सबसे वो लगे तो जो ऊपर वाला है मगर तो वो बोल
18.
can to case. Can copy to Sabole.
Make video lodge. This is the application under 480.
18 also we have received the case scan record? Yes. Yes. Yes, please.
Scan copy I send.
So here, your lordship,
I have received the scan copy to some.
Scan
We have
copy is
received.
there, man.
here, your lordship, the petitioner was arrested on 16/11/2023 under section 21C of the
16/11.
11/2023 under section 21C 29 of NDPS, your lordship. There were 9 listed PWs, only 1 examined as per my instruction. As of today, your lordship, in this case, heroin was recovered from a Tata Winger. Basically, my case here is in the ground of non-furnishing the ground of arrest to the petitioner, which is.
Otherwise, you are caught red-handed here. From your
This
position,
case-
as per allegation.
Yes, as per allegation, this is a Tata Winger from where it was recovered.
Recovered.
I was present in that
As a passenger, driver,
as
or
a driver.
as a driver.
Page 29, your lordship will find me. PW1 annexed by the
Page 29.
page 29.
This is the statement of
When the
PW1.
have asked the identity of the driver and occupant of the state vehicle, they have identified themselves as Elias Khan and Sirajuddin.
So Ilyas Khan is the driver
Right.
and the other one is occupant. Here your
From the
lordship, Ilyas
vehicle.
Khan has come before your lordship.
You are for Ilyas Khan.
Ilyas.
Caught red-handed wala আছে যে process position wala সেইটো দিলে submission কৰিলে সেইটো আনি দিব ইয়াতে ঠিক আছে
Arrest memo notice can be asked. So, arrest memo and notice have been given in the additional affidavit, page 36 and 37. Next, we have the- So, vehicle.
yes Kusami admitted the
Similar submission.
Same. But they are not okay.
same submission can be recorded.
Yes.
We have already submitted the length, we have already recorded, Mr. Manna. So we'll record this one. Kali auto yate likho, arrested on 16/11/2023. Yes, 23. And 9 PWs listed, 9 PWs, 1 only examined. He was the driver of the vehicle, not aware of Likhito about the contraband. Our Gusami submission, that is a conscious position wherefrom the contraband was recovered. And he was well aware about,
There which is
The-
implicated regarding the speaker's compartment.
yes, he was aware about the contraband, or baki same take. It is caught red-handed wala matters. Huh? So it is of satisfaction of whom?
No, court ma, come to. Ifu Karbi Angle.
Special Judge Difu Karbiang. Okay, Mr.
Yes, yes.
She is still typing. Right? This Sharmila. Who put this na? So I. So submission করে দিতে দাও।
Text to what we are waiting for this. Discharge.
Order the gas next.
19.
In this case also, your lordship, the petitioner was arrested on 35/2024 under section 21C of NDPS. 594 grams of heroin was recovered without container, your lordship, in this case. And here, your lordship, the co-accused have been discharged by the trial court itself on 22/1/2025. Charge sheet has already been filed on 16/9/24. Charges have been framed on 5/2/2025. Here it is been.
5/2/25.
Here, your lordship, the 594 grams of heroin was recovered from the bag in the Rajdhani Express. And it was doubted that the bags belong to the present petitioner in this case. This is the basic fact of the matter. Your lordship can. The FIR, your lordship, is that at page 12.
Now your petitioner's name is
Here
Amir
in
Khan.
this Amir Khan. was from Rajdhani Express. It was recovered at. The passenger was sitting at seat number 41. And on an inquiry, he disclosed about the bags, and from there, your lordship, 50 packets were recovered.
So
and
now also you admit that the bag is yours or you are not, do not
no,
admit?
admission is not there in this case, and here, your lordship, since no evidences have.
No.
It is
As,
in
as
this-
case reference, you am saying, asking.
It has not been admitted by the petitioner.
No, because I am asking that whether you admit this is a conscious position from your side. It's not, no.
He may submit with regard to that. And in this case, your lordship, also we have filed an additional affidavit and annex both the arrest memo and the section 50 notice. That is, your lordship, find at page 65 and 67. We have also given the type copy. But 65 and 67 are can be it can be made out.
So page 28 is a seizure list, my lord.
28.
Lordship will find one. Petitioner is one, is the petitioner from whom the 50 packets of suspected heroin weighing 604 grams has been seized, my lord.
No, it is 594 without the container.
To say that it was seized from his conscious.
Conscious possession commercial quantity. Even we take 500 grams, that is also commercial.
Yes.
And also charges framed on 5/2/25. The next date was for the 19/3/25 for evidence.
But I don't, there is no ability for them. No witnesses have come
As per your instructions. Same take I heard Mr. Y.S. Manna, Legal Counsel for the so and also heard Mr. M.P. Gusami. So. Date of arrest is 30/5/2024. 594 grams of heroin is alleged to have been recovered from his possession without container. There was no recovery from his conscious position. And Baki, the case has already been charged. Charge is also framed on 5/2/2025, but till date, the prosecution could not examine any of the witnesses. Aru ekhetor submission baki non grounds of non-arrest আছে section 50 CRPC আছে ইয়াতে Goswami mate it was from the conscious position of the accused petitioner. From the seizure list, it reveals that the recovery the quantity of the recovered heroin was 604 grams. However, with the container, accordingly, he submitted that a commercial quantity, the direct conscious position, same take his submission. And this is also case from most probably Kamrup Metro. Yes, it is disposed.
Obliged.
Yes.
May it please the lordship. My petitioner before a lordship is a driver of a goods carrying vehicle, my lord. And on 19/2, my lord, when the vehicle was stopped at the Naka checking, my lord, the vehicle was loaded with 12,000 kilograms of rubber sheets. And in between these rubber sheets, my lord, 1020 kgs of ganja were recovered. Accordingly, my lord, he was arrested and forwarded to judicial custody on 19/2/2023, my lord. And since then he's in custody, thereby, my lord, he has
Just a second. Yes, Goswami, do you
Yes,
have
ma'am.
anything here?
Yes, my lord. Here,
LCR is there, my lord.
LCA is there, my lord. On the merit part, my lord, PW 1, 2, and 3 examined, my lord, and from there, my lord, is 29/1. Next date is fixed on 36/25 for further evidence, my lord.
Last, my lord, it was last posted on 3/4/2025. On that date, trial court, my lord, fixed the matter on 36/25 for recording of my lord, issuing someone, my lord.
Last date was?
3/4/2025. Thereby fixing the matter on 36/25, my lord. And-
after 2 months,
Yes, my lord. So,
more than 2 months.
Yes, my lord, yes. So, my lord, charge sheet was also laid, my lord, and on 17/11/23 charges framed. Thereafter, my lord, the prosecution could examine only 3 witnesses, my lord, out of 8 listed witnesses, my lord.
So your period of heading,
Yeah.
detention is now
As on today, my lord, 2 years, 2 months, 25 days, which stands at, my lord, 815 days, my lord.
So we
But
can
there-
hear on the merit of the case.
That's
Now, apart from that, most probably he has also taken the ground of
No,
not
my lord,
partic-
through pleading, I have not raised, my lord, this issue.
Okay, okay.
but,
We can hear on the other, in merit also.
Yes, my lord, but the trial court records are there, lordship will definitely find the same notice, my lord. So, my lord, I have, my basic submission, my lord, is that I have already, my lord, spent on 815 days. And from the progress of the records, my lord, after perusing the trial court record, it can be seen, my lord, that the completion of trial in near future is quite impossible, my lord. It will take some more time, my lord, in completion. So, my lord, considering my detention,
As a whole, how many witnesses you have seen?
3 witnesses. I have
No.
8, my lord,
Listed?
8,
Eight
8, my lord.
witnesses.
8, and lordship has also seen, my lord, the duration of evidence fixing the matter, my lord. Perhaps it will take another, my lord, 2 years to complete the trial. So, my lord, considering the length of detention, my lord may kindly consider my liberty, my lord, conditional liberty with any stringent condition. I'll face the trial, my lord.
Yes, Kusam.
Yes, madam. Out of the 8 witnesses, my lord, 3 already over, my lord. But if we go by the witnesses, my lord, the witnesses has implicated the petitioner that the contraband has been found from his possession, my lord.
For the
And
vehicle,
it is not that, my lord, that there is so much inordinate delay, my lord, without any witnesses, my lord. And here is a case of only 8 witnesses, out of the 3 gone, and from the 3 witnesses, the case is, my lord, tilted in behalf of the prosecution that he is in possession of those contraband.
Those witnesses are implicated.
Implicated, my lord. So, my lord, at this stage, my lord, the embargo of section 37 will apply, my lord, here, my lord, because my lord could not show, my lord, now the burden is on as per section 50, my lord, burden is on him, my lord, to rebuke that section, that how he got the position of those articles, my lord. It will be on him to rebut that, my lord, because after possession is clear, my lord, it will be duty on him, cast on him to show that how the contraband has been in possession in vehicle, my lord. So at this stage, section 37 squarely applies to this case, my lord. So bar is there in now, my lord. And regarding the delay part, my lord, there is no inordinate delay, my lord. Trial is going on, next day it's fixed also, my lord. So there is no inordinate delay, my lord. And in that regard, my lord, section 37, my lord, lordship has seen, my lord, regarding that is my Mohit Chauhan's case, my lord.
Mohit Agarwal.
Mohit Agarwal's case, my lord, where it is still, even the delay is, even there is delay, my lord, it has to be balanced with the section 37 cannot be overlooked, my lord, even when there is delay, my lord. And there is also other judgment, my lord. And in the honorable court, our honorable court also decided in that favor, my lord, if section 37 cannot bypass the section 37 if there is no inordinate delay. And so far that my lord, regarding the decisions rendered by honorable apex court regarding the delay part, my lord, there, my lord, the facts are different, my lord.
So obviously.
Yeah, there is not alike in this case, my lord. Objection in this regard, my lord. And regarding section, my lord, notice part also I have objection because it does not, it will not be, my lord, overt by the behind commerce judgment here.
my lord, regarding Mohit Chauhan, what my lord, additionally PPS said that delay. Mohit Chauhan discussed that immediately after charge sheet, it is not a delay. An inordinate delay was never discussed, never my lord, argued, never discussed in that judgment. Only that the court said that if charge sheet is filed, that cannot be treated as a delay. Here, lordship has seen, my lord, on 17/11/23 charges were framed. Till date, only 3 witnesses has been examined, and that too, my lord, the intervals are very long. So that will, my lord, come under the definition. So definition, my lord, inordinate delay. So far, as section 37 is concerned, Lordship, there is plethora of judgments of our court as well as my other courts which held that if there is an inordinate delay, the bar of section 37 will succeed, my lord. I'll be also, my lord, place one small compilation, my lord. Where, my lord, yes, my lord. Two judgments I'll request your lordship to peruse. My page 7, lordship, may kindly peruse, my lord. This is from our Honorable Guwahati High Court, my lord. Our court, my lord, rejected the prayer of delay, my lord. So the petitioners went to Honorable Supreme Court and just my lord, paragraph
This is of Dhirendra Kumar Chaudhary.
yes, my lordship has also, my lord, gone through many times. So, my lord, there the Honorable Supreme Court said that they only 17 months they were in custody, my lord. And the Honorable Supreme Court said that the accused petitioner has a right to speedy trial. And only on that count, my lord, they were granted bail. Now, my lord, coming to the second judgment, this also, my lord, our Honorable Zakirul Islam, my lord, which is at page 10, my lord. There, my lord, facts was that some contrabands weighing commercial quantity 10,000 yabatas were recovered from the possession. 6 listed witnesses were there. During when they approached the High Court, my lord, out of 6, 3 witnesses were examined, my lord, within a period of 1 year, half month. Considering that, my lord, Honorable Supreme Court has granted bail. Only 1 year, 6 months. Here, lordship has seen, my lord, I have only, if we lordship takes the 36, 2025, perhaps it will be, my lord, 2 years, 5 months in custody, my lord, in my humble submission. So, my lord, considering these judgments, and my lord, lordship may kindly consider my prayer. I'll abide by any condition, my lord, and I'll face the trial, my lord.
Here, my Mohit Agarwal's judgment is my lord of 3 bench judge, my lord. So it's clearly says, my lord, any delay, my lord. It's not differentiated there after such it, before such it, my lord, as my learned friend has said, my lord. Because if you lordship will go through the my lord, remaining part of the judgment, my lord, is very much clear, my lord. Even section 30 cannot bypass us. Because the 3 judgment. And also, my lord, our court, our honorable court also decided on BA 2596 of the 24th. So I'm relying on that.
BA 25.
BA 2596 of the 24.
2596
24.
02.
Bablu Pandey versus State of Assam. Kindly go through the judgments and pass out. There is no assumption.
Not to listen.
And it's a case of conscious pollution and commercial quantity.
And state on 19/2/2023 with the allegation of 1020 cases of ganja. 1020 cases of ganja. Out of 8 PWs, 3 examined, and the case was last listed on 3/4/2025, and next date for evidence is fixed on 30/06/2025. সেইখানে গতিকে inordinate delay হ'ব patient আহিছে. He is in custody since last 2 years, 2 months, 25 days. So long incarceration of a period of. You see some. I have cited some evidences, judgments here. So can nalage Dhirendra Kumar Chaudhary mainly basically COVID. That's a state of all of a submission. Out of 8 witnesses, 3 has already been examined. So there is no such inordinate delay. Apart from that, on the PWs which were already examined by the prosecution has implicated the present petitioner's involvement in the alleged offense. And cited the witness of Mohit Agarwal, and Mohit Agarwal. Asylum BA 2596 of 2024. Bablu Pandey versus State of Assam. So no such inordinate delay to asylum, and 37 record of 37 will follow. Okay, we'll note. Okay. We'll see and pass the order.
It results.
The petitioner is in custody since 3/9/2023.
3/9.
2023. There is a incarceration of 619 days, about 1 year, 8 months, 11 days.
Yes. What is the stage of the case?
Till date, the prosecution could not even
Products
arrange
in-
for the framing of charges.
Why?
Lordship, every
Is there
time-
any absconder accused?
Yes, there is one absconder.
Two accused, and one
Uh,
could not be arrested, my lord. He is absconding, my lord.
One is still absconding.
One is still absconding. For that.
One is still absconding. no?
First sheet laid down on 18/2/24. Wait.
CS on 18,
18/2, 24.
24.
Not
So charge could not be framed as one is still absconding.
still absconding.
And another ground is that the grounds were grounds of errors that has not been communicated. The seizure was about 71 packets of ganja that was seized from the third and fourth chamber of the partition of the oil tanker. This was the oil tanker.
From oil tanker?
Yes.
Page 22, a lordship will find. Seizure.
Please 20.
20.
Yes, 22. This is the seizure list.
This is a seizure.
Articles from the possession of the driver of the vehicles bearing registration number such and such.
Number
namely
2 will be relevant.
Milton Sarkar.
Hmm.
Milton Sarkar. Is it such and such? And 71 numbers of packets. It's total 1420 kgs.
1420.
20 1450. 20 kgs.
The listed witness are eight number of listed witness. So there is no possibility that even the trial will commence anytime soon. Secondly, your lordship, there is a violation of Article 22(1) and 5 of the Constitution that will automatically override the statutory embargo. So considering these two grounds, your lordship may allow. I have the certified copies also, if your lordship.
Pardon?
I have the certified copies of the notice, inspection memo and all that.
Apart from that, we have also received the scan copy also.
Scan
Therefore,
copy,
also, it was section 50 or 47 as per you?
That may be section 50.
50. 50.
50. Lordship, kindly note that the arrest was made on 3/9/23.
Hmm.
So,
3/9/23.
yes, ma'am. So,
So there are, yes, obviously, they, on that count, most probably 2-3 matters have already been fixed for argument. But here, if you see a matters are different, yes. So he is on 1 year, 8 months, and one is still absconding. That is maybe the in period of that was one of the ground. So we won't pass any order on that. In fact,
yes,
there may be one ground for non-furnishing 50, but you have already submitted that on that trigger. You want to submit anything.
yes. If
So we are not going on that merit.
That-
Okay, then, but simple submission will be
in
made.
December, and my lord, they have not made any prayer also for splitting up the trial or.
Yes,
They
splitting
have-
up of trial.
yeah, they have accepted everything, my lord. So now at this stage, my lord, whether is there no endeavor upon themselves also, my lord, for speaking up or framing the charges, my lord.
Hmm.
And one
Obviously.
person is absconding, my lord, it creates some difficulty in proceeding with the trial, my lord. When they are co-accused, my lord.
That is understood, but
Yes.
obviously you have rightly submitted that prayer could have been made before the trial court for to splitting up of his case.
So, but they are not agreed at that time.
Mm.
Your lordship, whether that is the endeavor of the prosecution of the accused, that is to be seen. They could have also very well submitted for splitting up. Because
Obviously, in both sides, I won't say that prosecution also or by the court Somoto also, many
Okay.
matters they are speed up. But there may be one application from your side also
That
for
also good,
splitting up the
because they
case
are-
record because
they
you
are
are in
taking-
custody.
And they are
That's
taking the delay ground now, my. Because they are
because,
so, that is the task upon them,
Your Lordship, I'd like to cite one judgment in this regard. In Javed Ghulam Nabi Shaikh versus State of Maharashtra. At paragraph 19, where the apex court has clearly laid down that if any effort has not been made by the state or the prosecuting agencies, they should not object to the incarceration in trials. Para
So
19
judgment is other way, Mr.
Right.
Goswami.
Sir,
That is the issue. Okay, if the state or the prosecuting agency.
agency.
and there are other judgments which. Yes, they are against them, my lord. It will be there, my lord.
There are.
Yes, my lord.
Anyway. Okay, heard Mr. S. Datta, the counsel for the petition. And also heard Mr. M.P. Kusami, the learned additional PP, appearing on behalf of state respondent. Bagi hini Maribo Kisa. He got arrested in connection with this 3/9/2023, 1 year, 8 months, 11 days. 8 cited witnesses. But till then the trial is not yet commenced as one of the accused is co-accused is still absconding. Though the charge sheet is filed on 18/2/2024. So within period of probability, liable eligible. And the head of submission from the conscious position from the Treasury list, it reveals that the contraband was recovered from the conscious position of so and so. 1420 kgs of ganjas were recovered. He further submitted that that the charges could not be framed till date due to absconding of one of the co-accused, but the prosecution, but the defense did not make any prayer for splitting up of his case from the other co-accused person for the speedy trial. In that context, in that context, Mr. Doctor submitted that there was no endeavor from the prosecution or state or any endeavor, sorry. পানি খাবো না কেন? পানি আছে নি গরম দিয়ে? There was no endeavor from the state or oblique with the prosecuting agency, including court concerned, to split up the case record of the present petitioner. As the accused has the fundamental right for a speedy trial as mandated under Article 21 of the Constitution. In that regard, Mr. Doctor also cited a decision of Honorable Supreme Court passed in criminal appeal number 2787 of 2024. Case para number 19. But you will be safe. Okay, Mr. Doctor, we are passing the order. We'll see to it.
Obliged.
1 year, 8 months may not be so delayed because 6 months is the minus.
Obviously. But now his question is that one is still absconding. So definitely it will take some time. That is his submission. Otherwise, we'll see to it. এটা লৈ ল'ব পাৰি নেকি? এটা লওক, এটা লওক। Wise man.
22.
Wait, please, your lordship. This is a 483 BNSS application. The petitioner was arrested on 18/10/2023, your lordship, under section 22C of NDPS, your lordship. Yaba tablets were recovered. Your lordship, in this case, only thing is your lordship has already granted bail to the co-accused, the main accused person, Habibur Rahman. I can't hand over to you. Already granted on the ground of non-furnishing of the grounds under section 50. This order, your lordship. The main accused Habibur has been already granted bail. They have been mentioned as local associates of Habibur Rahman in the FIR. And the recovery was from Habibur Rahman. That person I have given So your lordship has already granted bail to the co-accused.
Here also you have taken same plea.
Yes, here your lordship, the Habibur Rahman was arrested from a hotel, from a Manipuri hotel, along with these two other persons. A bag was recovered from where Yaba tablets were recovered, and the person was Habibur Rahman carrying the bag. These two persons were local associates as per the FIR. And thereafter they were also arrested. And in that case itself, your
No, but they
lordship,
were arrested from that
Same
hotel only, same hotel.
Same. In this case, the Habibur Rahman case, your lordship, while granting bail, has stated that the petitioner is nowhere connected. So same, your lordship, in this case also the.
No, that was his submission, in fact. And so your witnesses, how many witnesses?
In this case, your lordship, the charge sheet has been given on 5/4/2024
Hmm.
and charges framed on 28/8/2020.
So till now, no witnesses examined.
No witnesses, your lordship. I have given specifically, I have stated in paragraph, one of my paragraph, that till today out of just a minute, your lordship, 1, 2, 3, 4, 5 dates have gone, but no witnesses have come. And he is behind the bars now nearly 1 year, 6 months. And and then I have annexed the non-furnishing of the grounds of arrest at page 40 of the application, your lordship, under section 50.
CRPC.
50 series. No grounds have been submitted.
Yes, Gusami, same submission.
That's already one. And that's been down.
Same ground থাকিব এটা ইয়াত আপোনাৰ submission দিছে from out of same FIR, out of same FIR.
Habibur Rahman.
Habibur Rahman. Co-accused Habibur Rahman is already granted bail, from whose possession the accused. The recovery was there was Alice recovery. The recovery was there. Not where from the Alice recovery was made from Habibur Rahman. He has already granted bail and ground of parity to DD4. And he is in custody since 8/10/2023. Sorry, 18/10/2023. Charge has already been framed on 28/8/2024. But even after lapse of 5 consecutive dates, the prosecution could not examine any witnesses still did. That next para, long incarceration anidiba, and next para, he also raised the ground of suens. Bakikini same takibo as from here. And Gusami's submission will be almost same. But there we have cited this one, it was from his conscious position, but now you raised this same conscious position issue, or because you were also there?
I was there,
Conscious
but there was
there.
only one bag, and that
Bag
bag was,
belongs to that
yes, the other.
other one. Conscious position to another again. Okay then.
Much of this.
Also, which is not received, your lordship. Lordship may fix a short date, as this is a Jalukbari case, and the accused petitioner is behind the bar now for 57 days, your lordship.
Cases of which nature? What?
Jalukbari PS,
No. Cases is registered under which section?
376 and IT Act 67, clause E, your lord.
Okay. No, he is in custody since last 57 days.
57 days.
Yes, 57 days, it is charge sheeted case. Or is the
Charge-sheeted.
case diary we needed?
Is a,
Already-
Charge sheeted,
Charge-sheeted.
already charge sheeted.
Scan copy was called for, not received.
Not received. As per office notes, or as office note, scan copy is not received. Issue reminder, registry will do the needful. Yes, email can be listed.
Lordship, on 20th, if it's possible. Next week.
Zero.
No, sir.
20, let us see.
It is a Jalukbari PS. Your Lordship.
Anyway, 208 minutes from us.
If now, if we are not concerned with PS now, case is pending before this
Your Lordship, then on
20?
24th,
20, you could say 21. 21.
obliged.
Any adjourn for the day?
You want an adjournment for the day?
Lordship.
We have received a scan copy here, I think.
Or scan copy receipt.
Pardon?
Receipt.
Scans copy receipt. At the request made by the learned counsel for the petitioner. Matter be adjourned. However, the scan copy has already been received. List accordingly. After 2 weeks will do. After 2 weeks. After 1 week, we do it. It will be after 1 week. After 1 week.
Lordship.
Deeply applies. Your Lordship.
Item 46 and 17. Yes, render. So should I put it now? The parties one.
Yes, or how will you set on the it could have some.
Item 47 of the supply list.
That's for bail hearing. These are all bail hearing.
What's the regular bail application, Lordship? Petitioner was arrested on Lordship 30/10/2024. As on today, Lordship 197 days.
38.
30/10/2024. 197 days as on today, Lordship. And the trial is going on, Lordship, under section 8 of the POCSO Act. And Lordship,
You are appearing.
notice was served, Lordship. None was appointed
Yes.
as amicus curiae, Lordship.
Yes. Already.
And Lordship, in this case, Lordship, 5 PWs examined. Lordship, total witness cited in the charge sheet is 8, Lordship. And 5 have been examined, Lordship.
5 already examined.
But one is, Lordship, not cited in the charge sheet. He is officer from the medical health department, Lordship, to prove the Lordship birth certificate. He is not cited, Lordship.
No, whatever 8
Among-
witnesses cited, 8 witnesses were
Yes.
there, and
Among the cited witnesses, 4 have been examined.
4 already
4
examined.
already examined. Including him, it is 5. Including the medical officer.
Okay, fine. And this victim and the
Victim, father and mother examined, Lordship.
victim informant are
Yes,
already examined.
mother also examined, Lordship.
Yes.
So right, my lord, victim's 164 statement and her depositions also, my lord, annexed, my lord.
Hmm.
The PW page 20 and 36.
I have annexed
My
the.
lord, already, my lord, almost, my lord, trial is about to be completed. My lord, the direction may be equal to expeditious disposal of the case.
No,
You have
Lordship.
already annexed it?
Yes, I have annexed the deposition, Lordship. 3 PWs. Subsequent to filing of this petition, 2 have been examined. 2 PWs, Lordship.
So where is the
That is-
victim? Victim is the
Victim,
page.
Lordship, page number, Lordship,
Page, my lord,
36.
36, my lord.
Victim, Lordship.
Victim. PW2. my lord.
PW2. He was examined on 11th of March, 2025.
This is case of section 8.
Section 8. Mom and daughter of the company were, Lordship, celebrating, Lordship, Diwali outside their house, Lordship, and cracking some, Lordship, firecracker. At that moment, this person came and touched the daughter of the Lordship victim.
Victim is, my lord, 12
12 years.
And my lord, accused person is of 36.
36 years.
Yes. And my lord, accused person, my lord, he is a permanent resident of Bihar. He will say,
Bihar.
yes.
That address I have given, Lordship.
Yes, children.
The period of detention your lordship may consider, but the person is permanent resident of Bihar. Is temporarily residing in Tinsukia, lordship. So trial is
Any
yet to
condition,
be
lordship.
completed, lordship.
The material witnesses
And
have
there
been,
is direct allegation by the victim, father and mother, and CCTV footage is also there, lordship. PW2 statements are very clear, lordship.
Hmm.
A man of 36 years, lordship.
lordship, the minimum punishment is lordship 3 years, and the maximum is lordship 5 years. And lordship, any condition he will abide by lordship. He will face the trial lordship. And all the material witnesses have been examined lordship. Only lordship
No, that is
Five.
examined, but his presence, I don't know whether it can be procured or not.
Not any-
Because
any
he is from
condition.
Bihar. No, condition
He's-
is all right.
He is Bihar, from Bihar, he is
Yes.
East Champaran lordship. Yes, he's from Bihar
Yes.
originally.
That's what I'm saying.
And lordship, the other ground also, though I have not pleaded non-furnishing of ground, lordship, it is in the record lordship. I have also the copy of the notice lordship. No ground is mentioned lordship. It's in the record lordship. I can lordship furnish the lordship certificate copy. 4748 lordship.
Heard Mr. N. Hassan, the learned counsel for the petitioner. Heard Mr. P. Botaku, the learned additional PP, appearing on behalf of state respondent. Mr. MS R. Chaudhary, the learned amicus curiae, appearing on behalf of the respondent number 2. This is an application, section so and so in connection with so and so. Scan copy of the case report has already been received by STC. It is submitted by Mr. Hassan that the present accused petitioner was arrested in connection with this case on 30/10/2024. And since last 197 days, he is in custody. He further submitted that the out of 8 cited witnesses, 4 have already been examined, including the informant, victim, and her parents. How further 1 court witness is also examined, the medical officer by the court, and only 4 remaining witnesses are left to be examined, they cannot be considered as vital for the prosecution case. So considering his length of detention already undergone by the accused, considering his length of detention and the status of the present case, he may be enlarged on bail. As the vital witnesses have already been examined by prosecution, there may not be any probability of hampering or tampering with the evidences of the witnesses. The person originally hails from Bihar, but he will abide by all conditions of bail and is ready to furnish the genuine surety as directed by the court. Next para, Mr. Botaku, the learned additional PP submitted in this record. That girl is of only 12 years of age, was only 12 years of age at the relevant time of incident, and she fully implicated the present petitioner. More so, the accused is from Bihar, and thus his attendance, there will be difficulty in attending, and hence the probability of absconding of the accused persons also cannot be denied at this stage. Mr. Botaku further submitted that 4 witnesses have already been examined by the prosecution, and hence the case is about to be hence the trial is about to be completed within a short period, and accordingly he raised objection and submitted that the bail prayer may not be considered at this stage. Next point. MS Chaudhary, the learned amicus appearing on behalf of respondent number 2, submitted in this report that DPW, the victim of this case, has directly implicated the present petitioner. And the victim was only 12 years of age at the time of incident, whereas the present petitioner was 36 years of age, who committed such misdeed with the present, with the victim girl. She also submitted that as accused hails from Bihar, thus this probability of absconding cannot be denied at this stage. Considering all the submission made by learned counsel for both sides, it is seen that the vital witnesses of the prosecution has already been examined by the court, and thus the probability of hampering or tampering with the witnesses probability of hampering tampering cannot be, and hence there cannot be any probability of hampering or tampering with the witnesses, the vital witnesses of the prosecution. So without going into detail of the merit of the case, only considering the length of detention already undergone by the accused petitioner, they will put some strict conditions there. You were allowed to go.
Lordship.
To whose satisfaction?
Additional session just comes special just POCSO 3
Tinsukia. Additional session just comes special just POCSO Tinsukia. Okay.
Obliged.
May I please, your lordship? For a TT application, lordship, petitioner was arrested on lordship 12/7/2021. And today is about 3 years, 10 months, 20 days.
3 years?
3 years, 10 months, 20 days. lordship. In this case, allegation is that lordship, some contraventions received by recovered here from lordship one courier service lordship. Then thereafter dummy parcel prepared and that was sent to Dimapur lordship, and thereafter there this person, these accused persons along with other accused persons was arrested lordship. And in this case, co-accused co-accused applied bail petition before the Honorable Apex Court lordship. Accordingly, notified lordship and fixed, to my information, lordship fixed the matter tomorrow before the Apex Court lordship. Because of this, considering this long incarceration lordship. No contravention recovered from my position lordship. Until today, in this case, charge frame on charge sheet submitted, and lordship final complaint submitted on 4/1/2022, charge frame on 21/2/2023, and till today, out of 7 witnesses, only 3 witnesses examined lordship.
LCR is necessary, lordship. LCR not received.
Not
LCR
received?
Not received.
To our information, registry received the LCR lordship, but it is not tagged, I think, with the record. No,
The registry has already received.
received to our information lordship. The lordship may fix this matter on Friday because we
No
can.
Friday. We are not fixing any matter on Friday. Maybe at best by Monday or Tuesday.
Because one petition is pending before the Apex Court, what will be the outcome of that lordship, we can see.
Tomorrow it is fixed.
Tomorrow, and lordship may fix tomorrow with the LCR lordship.
Tomorrow is not possible. That's what civil matters is also there. It will take time. Tomorrow and 16th, we are listing less numbers of matters because there are some urgency. 20 or 21. 20 or 21 and
Monday.
Yes, Monday may not be Monday, Tuesday, 20. Because Monday 19th also there are many matters, I think. So it may be on Tuesday, that is on 20. And if it's as per your information, if it has already been received, otherwise we'll issue reminder. It has to come from this Kamruk Metro or
Yes, it's Kamruk Metro.
Kamruk Metro.
It is a 5.
Otherwise also make an inquiry through office But if it is already there, then it's okay. Otherwise, we'll also issue a reminder. Have you furnished your objection here?
Yes, yes.
Objection is also there.
This is there, Lordship.
Then suppose if in any case by Monday, Tuesday, if LCR is not available also, in that case, if you have already filed your objection, you can submit from your objection also. Because there is, I think, then as per her, he is more than 3 years in custody,
Yes.
about to be 4 years, in fact.
4 years.
So that
About
is
4.
long incarceration otherwise. So otherwise, we are fixing it on Tuesday, that is on 20. As per office note, CD LCR is not been, scan copy of the LCR has not been received. Issue reminder. Registry will do the needful, list accordingly on 20.
Highly obliged. 49.
That legal lordship.
Yes,
For the last 55 days, we are in custody, my lord.
last
55 days.
55 days.
Arrested on 19/3. Initially for 5 days, we were in police custody and thereafter in judicial custody, my lord. Case is registered under subsection 2 of section 316 and subsection 2 of 318 of the DNS. Criminal breach of trust and sitting.
These are criminal breach.
Breach of trust and sitting, punishment that is prescribed. And my lord, we are not actually FIR named. The contents of the FIR, it is confined only to the 2 accused named in the FIR, my lord. Lordship, the vernacular one, lordship will find it page number 18. Logged by one Pallavi Vora. The 2 FIR named of Pranjal Deka and Kosik Sodari. At page 18, my lord. And as stated in the forwarding, my lord, this Kosik Sodari has uttered the name of the present 2 petitioners before your lordship.
Yes.
And
Otherwise, you are in custody for last 55 days.
55 days, my lord. It is also, while seeking police remand, it is also said that we have also some other associates at Silchar, Dimapur and such like places, and which are required to recover and verify the authenticity and ownership details. Now the CD will speak whether in reality we are not taken to either Silchar or to Dimapur. Who are the other associates?
316 is 90 days or 60? 316.
316 years.
DNS photos. Nothing has been seized from our custody and possession.
Be honest.
Seven years.
No. My lord, 316. 216 subsection 2.
90 days.
It is for a term which may extend to 7 years. No, which may extend to 5 years. Subsection 2. 316. And 318, which may extend to 3 years.
Yes, Bhattakur, otherwise it seems to be 60 days offense. So what is your progress now? As per him, he is in custody since 55 days.
My lord, there are sufficient incriminating material. I will point out to your lordship, my lord. Regarding the yes, initially, my lord, FIR is laws against my lord in the FIR name of 2, my lord, Pranjal Deka and Kosik Sodari is there. Thereafter, my lord, during investigation, my lord, there are
my lord, many other victimized person has lost FIR by naming the present accused persons, and those copy of all those affairs, my lord, here in the case diary, and those are, my lord, tagged as supplementary FIR, my lord. And here, my lord, what these accused person has done, my lord, they are involved, they along with their associates, my lord, already police has arrested one Pranjal Deka, Kaushik Chaudhary, Ankur Gogoi, Parag Dihingia, and one person from, my lord, Manipur, my lord, Soren Simrai, and one of the main accused, my lord, Tel Singh Zone. My lord, he is yet to be arrested. My lord, what happened, my lord, in this case, this accused person has collected documents from the various victimized persons, and thereafter, my lord, by submitting those documents to the, my lord, dealers, my lord, they obtained, my lord, vehicles in the name of those, my lord, owners. And thereafter, my lord, not only these allegations, thereafter, my lord, what happened in many of the affairs, my lord, by way of notarized agreement, they took, my lord, vehicles of some of the victimized persons, and thereafter, my lord, they were supposed to, my lord, pay them rent. My lord, thereafter, none of the vehicles were traced, and all those vehicles were sold by these accused person to Manipur, my lord. And regarding that accused person statement is also available, my lord. And here there is a long list of, my lord, name of the victimized persons and the name of their vehicle details, my lord, who is the present petitioner, my lord, took from them, and thereafter, my lord, sold all those vehicles, my lord. And your lordship may kindly peruse one of the statements.
No, but the only question I just answered from your submission, it is seen that
Other
there are
all
many
procedure,
matters.
my lord, from the police has also, my lord, served notice under section, my lord, and thereafter grounds of arrest also mentioned, everything is there, my lord. And because, my lord, this is a, my lord, all these associates are, my lord, this is a, this is type of offense, my lord, that no, it cannot be said that only many other accused persons who are from Manipur, my lord, main accused person, he is yet to be arrested, and those vehicles are also, my lord, yet to be, my lord, recovered, my lord, where they sold those, and my lord, IO has also procured the bank statement of the accused persons, and the bank statement also revealed there is, my lord, link between all these accused persons. All those details are here in the case diary.
Okay, that's why I just asked initially that what is it a case of 60 days or 90 days? Because as we have submitted, there are many FIRs filed during the investigation.
Yes.
Apart from that, as we have submitted that he is the person who actually took vehicle from the other persons, and apart from that, it was sold out. So these are there. The incrementing materials are there, I think. Bank statement may also be one of the. But the question is that whether the case is at this stage, is the almost investigation is completed, or that is the question I asked.
Investigation is going on. And regarding, my lord, 316, my lord, sorry, I'd like to point out criminal breach of the 3165, my lord. Earlier provision is 409. My lord, there is a criminal breach of trust by public servant, banker, merchant, or these are the agents, my lord. So here, my lord, imprisonment is up to life imprisonment. So punishment is 90 days.
But here is not, I not find.
3165, my lord.
3165 or 3162?
Yes, it's registered under subsection 2, not on 5.
3162, my lord. Yes, sorry, my lord. Otherwise, my lord, in case of 60 days of offense also, my lord, my prayer before your lordship today, as it Monday night.
55 days. Ekdin baad ki sunna.
Otherwise, my lord, present status is that investigation is still going on, and main accused person not yet arrested.
Otherwise, also, as you have submitted 3165, if we go by 3165 also, 3165 also, these are not the government service interested. That is not there, because they're not any government servant or any interested entrustment was there. If the entrustment was there, where some person, for that reason, some affidavits, etc. were there. But otherwise, 55 days within more 4 or 5 days, there may not be any probability. That is the only reason I just ask you, because there are materials, and the case nature is also a very thing, because they took the documents from the persons, and then it was used for. So
It's only with your lordship.
heard Mr. P. Decker, the learned
B.
counsel.
Bora, my lord.
Sorry, B. Bora.
Yes,
B. Bora.
B. Bora.
Heard Mr. B. Bora, the learned counsel for the petitioner. And also heard Mr. P. Botapu, the learned additional PP appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. His diary received, whereas received. Next paragraph, this submitted by Mr. Bora that the present accused petitioner is innocent and he is no way connected in the alleged offense. More so, he is not an FIR named accused. However, on the basis of statement made by on the basis of statement made by the co-accused, he got arrested in connection with this case. Full stop. He was arrested on 19/3/2025, and after arrest, he was also in police custody for 5 days. Presently, he is in custody for 55 days, and hence, considering his length of detention also, his bail may be considered. Post. The accused, being a permanent resident of his address locality, will provide a sufficient security, and there is no chance of absconding. Post. Rather, he will extend his cooperation in the investigation of this case. Next paragraph, Mr. Botapu, the learned additional PP submitted in this regard that the present accused petitioner is one of the main culprit of this case, and during the investigation, several efforts has been launched against the present petitioner, which were the petitioner, and he is the person he is the person who.
Well, there are two petitioners.
Two petitioners.
Two petitioners are there.
Who are they? One is?
One is Ankur Gogoi, one is Parag Ding.
One is Ankur Gogoi and one is Parag Ding, yeah.
Yes.
And they are the main persons who used to obtain the documents from the various persons, including some bank documents, etc. And then they obtained the vehicles, and thereafter, through notarized affidavit, but by executing notarized affidavit, they sold the vehicle to other states. Full stop. Some of the co-accused are yet to be apprehended by police, and more so, the vehicles are yet to be recovered by police. However, he submitted that. Full stop. However, Mr. Botapu submitted that the case is still under investigation, and the still under investigation. Full stop. Next paragraph. Considering the submission made by the learned counsel from both sides, it is both sides, and without going detail into the merit of the case, I find that the case is still under investigation, though the present petitioner is in custody. Since last 55 days. So only considering the length of detention undergone by the accused petitioners. Both the petitioners arrested on the same day.
Same day.
To whose satisfaction this one is from?
CGM Dorang.
Dorang.
Mongaloi.
To the satisfaction of CGM Dorang. Bill did it. Okay.
Obviously.
Already notice served, my lord.
Maybe the lordship.
Notice served.
Notice served, yes. I have received.
Yeah, as per lordship office note, notice served.
That may be kept as a part of the recording.
As per your instruction,
Yes,
notice
yes,
served.
notice.
And LCI has also been received, lordship.
Heard Mr. N. Hassan, the learned counsel for the petitioner. Also heard Mr. P. Botapu, the learned additional PP, so and so. Scan copy received, right? Scan copy of the case record has already been received. And it is also submitted by Mr. Botapu that the service is also completed on respond number 2. Poster. However, no one has appeared on behalf of respond number 2 accordingly. I find it proper to appoint an amicus to represent respond number 2. Yes. Accordingly, Mr. S. Das is hereby appointed as an amicus to represent the respondent number 2. Full stop. Registry will do the needful. List accordingly when it can be listed.
Lordship on
21st.
21st.
31st,
21st.
21. 21.5. Okay, we'll list it.
51.
May please your lordship. Lordship petitioner was.
You have already filed your objection here?
Yes, ma'am.
Oh.
It's been final. Record SMS, record as. Petitioners were arrested on lordship 15/9/2023. Today is about 1 year, 8 months. In this case, final complaint filed on 28/2/2024.
20, 20?
28/2/2024. And then 12 numbers of witness cited in the final complaint. Out of 12, 3 examined lordship. And charge them on 14/10/2024.
Charge on?
14/10/2024. In this case, lordship, final complaint filed against 4 accused person. Out of 4 lordship, already 2 already got bail from the Honorable Court. And lordship, we have taken another plea, lordship, regarding non-compliance of the 50 and 50A lordship. 50, we have annexed at page number 87 lordship.
Here, my lord, in
Page 87 lordship. Here, lordship, they have cited the reason, but they obtained the signature of the accused, thumb impression, lordship, at the signature of the accused column. So, lordship, as per Bihan Kumar, lordship, lordship is aware about the citation. Even after that, lordship, kindly go through paragraph number 13. Paragraph 13 lordship. May I read, lordship? Paragraph 30, inside the paragraph 13, paragraph 20 of Lalu Bhai Jaggi Bhai Patel. So it is an admitted position that the detainee does not know English. The grounds of detention which were served on the detainee have been drawn up in English. It is true that Sri C.L. Antali, police inspector who served the grounds of detention on the detainee, has filed an affidavit stating that he had fully explained the grounds of detention in Gujarati to the detainee, but that is not a sufficient compliance with the mandate of Article 22(5) of the Constitution, which requires that the grounds of detention must be communicated to the detainee. Communicate is a strong word. It means that a sufficient knowledge of the basic facts constituting the grounds should be imparted effectively and fully to the detainee in writing in a language which he understands. The whole purpose of communicating the ground to the detainee is to enable him to make a purposeful and effective representation. If the grounds are only verbally explained to the detainee and nothing in writing is left him in a language which he understands, then the purpose is not served. And the constitutional mandate in Article 22(5) is infringed. If the authority is needed on this point, which he so obvious for Article 22(5) refers be made to the decisions of this court in Hari Kishan versus State of Maharashtra. Then therefore, as far as Article 22(1) is concerned, a compliance can be made by communicating sufficient knowledge of the basic facts constituting the grounds of arrest to the person arrested. The grounds should be effectively and fully communicated to the arrestee in a manner in which he will fully understand the same. Therefore, it follows that the grounds of arrest must be informed in a language which the arrestee understand. That is how, in the case Pankaj Bansal, this necessarily be meaningful so as to serve the intended purpose. However, under Article 22(1), there is no requirement of the communicating the grounds of arrest in writing. Article 22(1) also incorporates the rights of every person arrested to consult an advocate of his choice and the right to be defended by an advocate. If the grounds of arrest are communicated to the arrestee as soon as may be, he will not be able to effectively exercise the right to the consult an advocate. This requirement incorporated in Article 22(1) also ensures that the grounds for arresting the person without a warrant exist. Once a person is arrested, his right to liberty under Article 21 is
Okay, then
curtailed.
you want to submit that as a person is a thumb holder. I mean, he is not a person of literate person. So how he will understand the language in
Lordship.
English?
In conclusion, also it is mentioned, Lordship, in the para 21B.
Para 21.
21 in conclusion, Lordship. Next page, Lordship. 21B.
Para 21. Yes.
21B.
Yes.
B. So it is clearly mentioned, Lordship, that sufficient knowledge of the basic fact constituting the grounds is imparted and communicated to the arrestee person effectively in a language which he understands. So in our case, one in thumb impression and one put his English, but it is not written in the documents in both in two persons were there. In one in page number
One person put the thumb impression, another one
put signature in English, but it is nowhere nowhere written that Lordship it was made understand to the accused person in his language or he understand this. So Lordship, in 87, it is nowhere stated that this person put his thumb impression, because we obtained the Wakalatnama that they have put their signature in English, Lordship. So whether these signatures of the accused persons, this thumb impression belongs to these accused persons or not, that is also doubtful, Lordship. And one more important thing is that, Lordship,
otherwise 87, the page number 87, he put his signature in English.
No, thumb impression.
No, here in thumb impression. Now we have said
It is 88.
No, 88 in English.
Yes.
But
In 87,
he also put his signature in English.
English. In other documents, thumb impression, Lordship. 87 thumb impression. So, Lordship, in this case, and one more submission is that, Lordship, section 48 now in CRPC 50A is also not complied with. So, Lordship, in this case, the other two co-accused got bail, Lordship. I have annexed those documents also. That is, Lordship will find at page number 89, Lordship. They are the person who booked all these things, and then they were arrested on the basis of the statement, Lordship, on the same night, Lordship, from some other laws. Page 89, Lordship.
Regarding the bail of these other two accused, madam, two SLP has been filed in Supreme Court from the department. SLP number 0041858/25 and SLP criminal number 0058881/2025.
But my lord, they have not violated any condition to my information because I am conducting the trial, Lordship. They in each and every day they are appearing before the trial court. They are facing the trial, Lordship.
But in the
These two SLPs are pending.
yes, madam. Because they have misled the court. Actually, they have hide some factual material in their bail petitions earlier. Yes.
But I have gone through the order sheet, Lordship. Here only on the basis of the statement 67, they have got the bail, Lordship. Honorable Court granted the bail by Honorable Justice Arundev Chaudhary, Lordship. In this case, Lordship, after receiving of the LCR, the Honorable Court has granted the bail on the basis of the statement these persons were arrested because considering this Lordship Tufan Singh judgment, and Palid Lordship, Labid Ahmed Lordship, that as per that judgment, Lordship, the Honorable Court granted the bail.
In this case,
So
my lord,
LCR was before the court, Lordship, after going through that judgment, after going through the LCR, Honorable Court has passed the order, Lordship. There, I don't think, Lordship, there is any misleading facts was there at the time of passing the order.
so in this case, my lord, the heroin seized heroin was 8.210 grams heroin has been recovered from this accused person. And regarding this, my lord, I want to rely on the judgment of wait. Please, para 19. In this regard, para 19. I will tell you. Para 19 says that this court has laid down broad parameters to be followed while considering the application for bail by the accused involved in offense under NDPS Act. In the Union of India versus Ram Samaj and others, SCC 429, it has been elaborated as under. It has to be borne in mind that the aforesaid legislative mandate is required to be adhered to and followed. It should be borne in mind that in a murder case, the accused commits murder of 1 or 2 persons, while those persons who are dealing in narcotic drugs are instrumental in causing death or in inflicting death blow to a number of innocent young victims who are vulnerable in causes deleterious effect and a deadly impact on the society. They are a hazard to the society. Even if they are released temporarily, in all probability, they would continue their nefarious activities of trafficking and or dealing in intoxicants clandestinely. Reason may be nurse tech and illegal profit involved. So, my lord, in seeing all these aspects, my prayer is not to grant bail to the accused persons.
My lord, in this case, Charles came on, as my learned friend made submission on merits. We are initially, Lordship, we file non-compliance of this section 50, Lordship, and 50A, Lordship. We are on that. Subsequently, as he has stated that he has stated on the merits of the case, Lordship, I would like to place my submission in this regard, Lordship, that Charles submit the case was intercepted on 15/9/2023 from a loss, Lordship. That is, it is Lamka loss from Bhangagar, Lordship. But no person from or no any registered from Lamka guest house, Lordship, or loss. We made witness in this case. We have crossed on that part, Lordship. No person from there. And then, Lordship, what happened? One box found inside the room. Whether that belongs to these persons or not, that is also not there, Lordship.
Already
So on-
statements are there, my lord. Their
Statements,
statements, they have confessed that those things, they have bought those things and kept in that.
Well, let me finish first, then she can reply, Lordship. So, Lordship, 67 is not admissible. That is the law set down by the Honorable Apex Court in Tufan Singh, Lordship. So 67 is there after arrest, Lordship, that is admitted after arrest, Lordship. 67 prepared by the officer, and the search and seizure not prepared or made at the place of intersection. They brought the person to their office. Then the office, all the things they have cleared up on that night, Lordship. So we are not right now on merit, Lordship. In in so many cases, Honorable Apex Court after elapse of 1 and 5 months, Lordship, 1 year, 5 months, Honorable Apex Court granted bail, considering long incarceration. We are on both, Lordship. In this Lordship, already 2% got till today. Honorable Apex Court did not rejected the bail petition of these persons. Already they are on bail, they are enjoying, they are appearing before the court. Whether misleading or not, that is, Honorable Court has gone through all the record, Lordship. After perusing the record, it was, if it is misleading facts in the petition, Lordship, Honorable Court already perused the record. Thereafter, Lordship, long order passed. And Lordship, they are appearing before the, we are not there. Their Lordship, they booked all these things, they arranged all these things as per their allegation, Lordship. So in this case, Lordship, Honorable Apex Court in 1 year, 5 months last year passed the order, Lordship. She has placed 20 judgment, Lordship. And this these are submitted. It is in second page, Lordship. Second page, first paragraph, Lordship. May I read, Lordship?
Second page, first paragraph.
Learned counsel for the appellant, Lordship, got it. Submitted that the appellant was arrested on 25/4/2023 and he was in jail since then, that is 1 year, 5 months. The charge sheet as well as the supplementary charge sheet have been filed, but the trial is to commence only in January 2025. It is not known as to how many witnesses have to be examined, that there would be a procrastination of the trial by the respondent, and the same would be prejudicial to the liberty of the appellant hearing. He therefore submitted that the order impugned in this appeal may be set aside and the appellant may be released on bail. So considering 1 and 5 months, 1 year, 5 months considered as long incarceration, Lordship. So in our case also, we cross more than that, Lordship, about 1 year, 8 months, Lordship. So in Ravi Prakash also, Lordship, it is clearly stated that in Ravi Prakash, Lordship, it is in paragraph. I'm reading this and then after this. As regards to the twin conditions contained in section 37 of NDPS Act, learned counsel for the respondent, the state has been duly heard. Thus the first condition stands complied with. So far as the second condition, reformation of opinion as to whether there were reasonable grounds to believe that the petitioner is not guilty, the same may not be formed at this stage when he has already spent more than 3 years and a half years in custody. The prolonged incarceration generally militates against the most precious fundamental right guaranteed under Article 21 of the Constitution. In such situation, the conditional liberty must override the statutory embargo created under section 37 1B2 of the NDPS Act. So Lordship is aware about this case, Lordship. So I'm submitting that one also. In merit, Lordship, we are inside the jail for about 1 year, 8 months. And non-mandatory sections right now, Lordship, in Pravir Prakash and Bihan Kumar, already 51 in put thumb impression. That is not justified by them why this in thumb, and then explanation is there in his language. He is a Manipuri
Yes, she is from Manipur.
Manipuri person, and then Lordship 58 grounds of arrest was not communicated to their family members. That is not there, Lordship.
As per the IO objection report, my lord, they were communicated to the family members of the accused in over phone. most communicable, understanding languages, because the person is Manipuri, and he was informed about all those things by Hindi, and to the family in the Hindi languages.
That is not sufficient, my lord, through the WhatsApp, through the mobile, that is not in the case recorders. That they have communicated to the family members on WhatsApp or to whom, lordship. That is not that, these all are threadbare discussion made by the Honorable FS in Prabir Prakash, lordship, and in also Bihan Kumar, lordship. I need not to reiterate all these things, all these paragraphs again and again, lordship is aware about these things. So with any stringent condition, lordship, they will face the trial at any, they will follow the, they will comply all the conditions as imposed by this honorable court.
They are outstations persons, my lord. Once they get grant bail, it's very hard to track them. And
Yes, we also are not ready, we know. It's very hard to track them and to procure their attendance is very hard. We know this. But, there are some, now it is the situation is a bit different, so we are dealing with some matters. Obviously, long incarceration is also there, and the grounds of arrest is one of the, we are concerned now. So, let's just see, we'll pass the order here.
But in our case, lordship, we have seen, in our case, nowadays, all the persons appear before the court. Earlier, there was probability, and on the basis of probability, lordship, the mandatory rights guaranteed under the constitution that lordship must be looked into, lordship. That is the thing.
23, 69 billion.
In some cases, lordship, sometimes if warrant issued, then again they appear before the court. In one day, they did not appear. The court.
It will happen if their address is proper, in fact. If address is suppose some, in some cases, there is address is also not proper. They avoid to give the proper address.
Yes.
So that may be one of the situation wherein court faces some trouble
Yeah,
with
exactly.
procuring attendance. This is the, nowadays is happening. And apart from that, if address is proper, it's not the case that the person, if he belongs to other state, he will definitely abscond. That is not the case. Yes, there are some situations, there are some cases wherein they are appearing, in fact.
Yes, yes.
But many cases we have seen that they abscond absconding. Now at this stage, many of the accused persons have already released on bail. The veteran criminals were already released on bail on these grounds. So we don't know, those matters may be pending for a, I don't. On merit, we have nothing to say, but.
We got lots of bail from this honorable court.
Yes,
In that
yeah,
case,
we are
lordship,
dealing with.
all are appearing, lordship. All are nowadays, lordship.
Okay.
Earlier, lordship, this happened because Manipur police did not communicate it to the accused person. Nowadays, lordship, they are communicating. The NBW also issued by the court that also communicated to the accused person. Because of that, lordship, their apprehension that they may be arrested again. That is why they are contacted us, and we made the application before, we made a prayer before the court, and accordingly, lordship, they are appearing each and every day, lordship.
Okay, because you are busy with this, deal with the trial matters in trial court. I know you, so there may be any knowledge for you. Okay, then we pass the order.
All right, sir.
Except to item 17 along with 46.
So I have checked the LCL also. Yeah, 47 is not complete.
Pardon?
We got the certificate, madam. So far item 46 is
I have
concerned.
gone through the LCL also. 47 notice is not complete.
It's not complied with.
Not in the final.
As a not complete.
Not complete, yes.
You have also filed here in item number
I
46 additional
but I
evidence.
got the certificate, madam. Item 46.
That is there in the record. I have flagged my details.
She is for 17, madam.
Lordship.
Both lordships.
For both cases, one LCR is there, Lordship. Same case. I have flag mark it also.
So what you have a flag mark there? No, no,
47 notice that is not properly, grounds of arrest is not mentioned properly.
complied with. And other in regards to merits, any other submission?
As that is the primary issue, Lordship, that is I have not gone for.
Otherwise, your petitioner is behind the
From
bar.
vehicle, my co-driver, he's the driver is some other person. He requested me to accompany him to Guwahati. Therefore, I accompanied for 1 day on the against rupees 1,000 rupees. So for the present petitioner, the driver, main driver is not your lordship, the co-driver, they have stated co-driver. This is the case. And 380 grams of heroin seized from the vehicle, from the back seat, vehicle doesn't belong to me, nor I am driver of that vehicle. This is my case. Paragraph 5, I have stated everything.
And
So
both the-
when you got arrested here in this case,
I arrested my on 1/11/24, 7 months. 100 my lord, 96 days today. 196 days.
take it, take it.
Charge should file, but charge not yet been framed. Charge should file on 29/4/25. On 46, not true. To 17.
47 GNSS in item number 11 arrest member 46 GNSS. Compliant. Date of arrest is 1/11/2024. CS filed on 29/4/2025. Charge not yet paid. And he is innocent. There was no recovery from his
In
constitution.
item 47, Lordship, he was arrested on 31/10.
In item 46,
1/11/24. Is on
just clarify one.
ground regulation.
আপনার কষ্ট দিলে দিদি লিখছেন কষ্ট দিলে সেগুলো করছি কষ্ট দিলে সব কষ্ট দিলে দিদি
1/11/24.
Is it 1/11/24 or yes, Doctor, is there any other
Yes.
date? Where is the forwarding you have annexed here?
Then my lord, actually arrested, but forwarded on 1/11.
1/11.
31st/10 he was
Arrested
arrested and 1/11 forwarded.
Special judge, my lord, that Amingaon.
Special Judge,
Amingaon.
Special Judge Kamrup Amingaon.
The 47 to 40 also.
আর বাকি বুঝতে রফর সলিউশন সেটাকে commercial quantity from conscious position. Seventeen science. Yes, in 17.
17 Lordship. I am arrested only on the basis of 67 NDPS Act. No conscious position, no recovery, Lordship. And
From
my
you, no
main-
recovery.
Yes, my basic ground is Lordship that non-compliance of 47 and 48, that in the LCR Lordship, that has been marked as, in the file B, that has been marked as flag A and B. Those are my, that non-compliance will show. That is
A and B. A.
A and B in the file B.
But Lordship, that ground has not been taken in the
Yes,
petition,
it-
Lordship, that has to be taken, Lordship.
Yes, that ground has been taken by additional affidavit.
Your petitioner's name is
Sanwar Hussain Lordship,
Sanwar.
Sanwar Hussain. By additional affidavit that.
So you arrested on the basis of statement made by co-accused.
Co-accused Lordship, and
Thank you.
here Lordship, I'm
Statement made by
I'm
co-accused.
relying with,
Consent, thank you. Are 47 or yes, non-compliance. Recovery was not, for your, from your position, there was no recovery.
No recovery.
No recovery from the position of sales. That is the ground.
And here are.
Have you seen this? You have marked also this Sanwar Ali also, na?
Yes.
Law court?
That is this. That green flag or one.
Green flag, yes.
Yellow color. flag.
Yellow
Both
flag.
are-
State or self-submission like that.
Lordship, here two judgments, Lordship. I want to
Yes,
place my
yes.
covered case. One is Lordship's order. One is Lordship's order and the other is Vihan Kumar's. Lordship is already available. Lordship's order in the same circumstance, Lordship, bail has been granted.
Okay.
I'm obliged, Lordship, and petitioner is the local person, Lordship.
Yes, to take a look. Listen, this can, just can you listen?
Fifty-two of the supplement.
My POXO 85 days today, my. And your lordship last time also, all desired consider, he was, now he has been appointed by amicus curiae. And so.
You have received here, but is it charge sheeted case or CD? CD.
CD, we have not received.
But charge sheet not been filed, my lord. And.
What is your custody, your in custody?
85 days, my lord, arrested on 30/4/2005, 25. 304.
So basically you are on the ground of detention, 85 days.
Plus that, your lordship, I got the certificate also, that is also not there, my. Yes.
Page 21 also. Page 21.
Certificate I am having now. That is a photo for you, page 21. huh? And page 22, my lord, 48 also, same.
So otherwise your petitioner is guilty.
Guilty, my lord, this, he was having some relation, but she was short of 11 months, my lord, to become 18 years. That's why, my lord, they were waiting for that, my lord, but she was pressurizing the petitioner, my lord. Once she came, and ultimately something happened, maybe, my lord, as per FIR, my lord. But actually, he is ready to bring her after one day. Condition was that you complete the age 18 years, then everything will be performed, my lord. That was because of that, my lord, this happened. But so far this ground is concerned, I think your lordship, because if the arrest itself is illegal, my lord, I think the statutory, otherwise 85 days, my lord, your lordship.
Yes, go for any other submission. No, obviously it is 85 days, so what where, your CD is not here.
CD,
No,
we have
CD.
not received.
So have you
Length of
any
detention,
information
I have-
regarding the filing of the charge sheet within 4 or 5 days, or is there any problem?
That instruction I have not taken, Lordship. LCD is not here, Lordship, and I have, we have so many. things to
Otherwise,
submit,
it is
Lordship,
a
but
section
Lordship-
6 POXO or 4 POXO? 4 POXO.
Four.
But the same ground is, again, that ground is taken, Lordship,
Yeah.
that is why. This is-
That itself
If the
gives
ground,
some
that
right,
ground
my
goes,
lord.
goes, then we
Subject to your
can submit
lordship.
anything, something more, Lordship, but if that is. not-
Okay, 4 or 5 days, my lord, otherwise that's it. Otherwise.
Yes, for a such.
But along the, on length of detention, that here I have objection, Lordship. Because Lordship, length of detention, Lordship, in some cases, their length of detention may not be counted, Lordship, because these are the heinous offense, Lordship. In heinous offense, Lordship, length of detention, 90 days is 90 days, Lordship.
No.
After 90 days, we have the time till 90 days, Lordship. So
That I am
we
not
have-
disputing on.
That is,
That part I am not
if
disputing.
Lordship is going to dispose it of on the merit of ground of election, Lordship 47 BNS, Lordship, then it is okay, but Lordship, in length of detention, I have to.
That's what I'm asking, whether is there any instruction from IO that everything is ready, you're going to file the charge sheet.
That I
If not is there, then it obviously length of detention is 85 days. That's what I'm asking. Yes, Bharat.
Since it's a POXO case, so length of detention may not be material. They have time till 5 more days to file charge sheet if they want. Otherwise, 47 might not be less.
And FIR is also my, you kindly say page 14, madam.
Page 14.
3 lines FIR, madam. Page 14, Annex 1.
Hmm.
As per the Vector State on last 18 to 20 at around 12 p.m. while I was not at the home, accused entered so and so 17 years 1 month. And when she even cried, accused fled away from the scene. Our case
Short FIR.
yes, yes, madam. Anyway, madam, I lift your worship on it. A special judge Vishwanath.
Hard Mr. H.R. Chaudhary, learned senior advocate, assisted by R.
Decca.
R. Decca, MS R. Decca, the counsel for the petitioner, and also heard Mr. B.S. Lawford, the learned additional VP appearing on behalf of state respondent, and Mr. D.K. Bhattacharya, the learned amicus curiae for appearing on behalf of the respondent number 2. It is submitted by Mr. This is an application under section so and so in connection with so and so. First of it is submitted by Mr. Lawford, the CD not received, and no intimation is received from the IO. First. Next paragraph, Mr. Chaudhary, the learned senior advocate, submitted in this regard that the accused petitioner is in custody
Since 18-2.
since
18-2, madam.
18 to or 30, 18 to
18 to 25.
18 to 25, and thus he is in custody since last 85 days, and hence considering his length of detention also, the prayer may be considered. Mr. Chaudhary further submitted that it is a fact that there was a relationship between accused and the victim, but as the victim did not has not completed her age of 18 years, he asked her to wait till her completion of 18 years of age to marry her. On that count, the FIR was lost against him with some concocted allegations. Next paragraph, Mr. Chaudhary further submitted that while arresting the present accused petitioner in connection with this case, there was no proper compliance of section 47 and 48 of the BNSS. Baki grounds of arrest not mentioned. When the short. Next paragraph, Mr. Lawford, the learned additional PP submitted in this regard that case relates to POXO, and hence the length of detention may not be considered at this stage, and will may not be considered at this stage. However, he submitted that that the accused he further submitted that the accused petitioner was arrested in connection with this case. Submitted that the accused is well aware about the grounds of arrest, and hence there may not be any written communication to that regard, but the ground of arrest is well known to the present petitioner. Accordingly, he raised objection and submitted that it is not so. Next paragraph, Mr. Bhattacharya, the learned amicus appeared on behalf of respondent number 2, also submitted that admittedly the victim was a minor at the relevant time of incident, and the length of detention may not be considered as the case relates to the POXO Act. Accordingly, Mr. Bhattacharya also raised objection and submitted that it is not a fit case to grant bail to the present accused petitioner, only considering the length of detention. Next paragraph, considering the entire submission made by legal counsel of both sides without grounds of arrest, and length of detention also you can consider because 85 days is there, and when last 47 and 48 are non-compliance. Okay, it is satisfaction of the special judge Biswanath, Biswanath Chariali. Okay.
This man is in custody for last 3 years, 2 months and 7 days. My lord, this piece of paper, my lord, I have jotted down the basic facts, my lord. This is arrested on 8/3/2022. Number of days in custody, 3 years, 2 months and 7 days. Charges framed on such and such. Charge sheet filed on such and such. Total witnesses 10. Witness examined 3.5 because the fourth witness is partly examined. And these are the grounds, my lord. And it was not, it was recovered from the possession of somebody else, Ashebuddin Bania. That is at page 53 of the bail application. He was arrested on the basis of statement under section 67, my lord. Prolonged incarceration itself is a ground. They have filed their objection, my lord. It is not denied. They also accept that he was arrested on 8/3/2022. It is there in their objection, my lord. If your lordship kindly takes up their objection.
Oh, you have not filed your objection.
They have filed their objection.
Oh, it's not tagged.
Requisition there.
It's
But
not
the
tagged.
case is made, day after tomorrow, Lordship.
No, we're not fixing on 60.
My lord, I have a copy of this, my lord. I can give. But she also have an official copy that can also be used, my lord.
Okay.
Or
Or you want some? Yes, what is your submission? You have already filed your objection, so objection is with you. We, due to some reason, the objection is may not be tagged with the record, but otherwise you can submit from your objection. Yes, supply me one copy. Otherwise, taking a ground of long incarceration because he is in custody more than 3 years.
3 years, 2 months.
Out of 10 witnesses, only 3 witnesses and 4 is yet to be completed. So that is the main position. And apart from that, the person was not, the recovery was not from his conscious position and was arrested on the basis of statement of Koigu. So 67 is there.
Absolutely.
So as per you, what is your submission? You have written some facts of the case here. And
Lordship, we-
some evidence is also against the accused petitioner. I have mentioned in your para 6, I think. There are some evidence available on the record against the present petitioner.
Lordship, objection may be recorded, Lordship.
No, obviously, we'll record your objection. Response sheet of paper 67 to Singh also recorded, and 47, 48 no need to be recorded. Only long incarceration can be recorded. Okay. And from your Kakoti, na?
Lordship. And Kakoti, Lordship.
Kakoti appearing on behalf of Mr. S.C. Kyle, the standing counsel. Is it NCB or dear? NCB. Most of it is submitted by her that the present accused petitioner is fully involved in the alleged offense. And during the investigation,
He was phone arrested in this case.
during the investigation, it was found that the present petitioner is also involved in the alleged offense. And accordingly, on the prayer made by the IO, the present petitioner was shown arrested in connection with this case. She further submitted, your petitioner's name is Abu Said?
Yes.
Petitioner is also a habitual offender and he is presently facing the charges in 2 cases. One another case in NDPS case and NDPS case, full stop. You're supporting here one Ajay Kumar, alias Pappu.
Yes.
Ajay Singh, alias Pappu, you have cited here.
These are co-accused.
Pardon?
Oh, it is judgment side question.
Ajay Kumar Singh, alias Pappu, he is co-accused.
Oh.
No, I think.
Evidence are available on record against Abu Said. My lord is reading page number?
Yeah, page number 6113, pair 13.
61. There is no para 13 in 61. Achha, in my bail petition,
No, no, no.
no, 61, there is no para 13.
He's there, objection we are reading.
13 not there.
Para 6, page 61, para 13. And Baki,
My lord, these are some other judgments which they are referring, my lord. These are this Pappu Yadav judgment of that Bihar case, my lord. These are not even NDPS related.
Lordship, he was informing some two cases, Lord sir.
Hey, attack case. Aase to do. No course, attack case.
yes, yes, in your objection, I have
It is
seen.
there, it is there.
He is also involved in another case.
Right.
Yes. That is there, we have seen.
I'm obliged.
Oh, we'll pass the order.
I'm with you.
Yes. Pardon? Yes, yes. Yes. We have received the case diary.
I am on interim for last 5 months, my lord. There's a dispute regard during, my lord, the last by-election, my lord, between the parties, cases and the counter cases, my lord. Probably custodial detention is no longer necessary, my lord.
Your interim was granted on 6/12.
Yes.
Yes. So in item number 25, there are how many petitions? 14.
14, ma'am.
All were in interim.
Yes, yes, all were interim. They have appeared also, my lord.
Because during that election or
By-election, my lord.
by-election. Oh. Yes, for as per him, otherwise they are cooperating. Is there any other?
Recorded lordship. Injuries are simple in nature. And though some life parties are seized from the place of occurrence lordship, witnesses has not implicated no one.
Because 25, 27 is also there.
But lordship, but no witnesses has implicated anyone lordship. Witnesses,
This what 14 petitioners.
both are almost same cases, but 25 and 26 total.
So
Both are
here
same.
we are for 14 petitioners. All were on interim since 6/12/2020. They are cooperating now. And injuries are found to be simple and not implicated.
Witnesses have not implicated him. And even there's some injured person who are by taking stone lordship, they have also not mentioned that those persons have thrown stones to fired on us. That is also not there.
Okay, and in 26, what is the position? Here also, how many? 3 petitioners.
3 petitioners.
26 to remove. Out of same FIR, these are also
Separate.
different FIR, separate FIR. Okay.
Similar incident, madam.
Incident of firing was happened lordship, that was occurred lordship, but who fired, that is not implicated by anyone, any witnesses lordship.
But firing was there.
Some cartridges were also recovered. Were also seized.
They almost the same over, but FIR are different. Huh? Both the FIRs are different, but otherwise the submission will be more or less same. Heard Mr. A.M. Bora, the learned senior advocate, assisted by Mr. A.K. B.K.
B.A. Chaudhary.
B.A. Chaudhary. the learned counsel for the petitioners, and also heard Mr. B.S. Lawford, the learned additional PP appearing on behalf of state respondent. This is an application and section so and so in connection with so and so. CD receipt, parents receipt. It is submitted by Mr. Bora, the learned senior advocate, that the present accused petitioners are innocent and they have not committed any such offense as alleged in the FIR. However, after obtaining the order of interim pre-arrest bail on 6/12/2024, they have already appeared before the investigating officer cooperating in the investigation, and their statements have also been recorded by the IO. The petitioners are still ready and willing to cooperate the IO in further investigation of this case if their pre-arrest bail prayer is considered at this stage. Next, Mr. Lawford, a learned additional PP submitted in this regard that there is no direct implications against the petitioners in the case record. However, there was an incident wherein some of the persons sustained injury, but as per the medical report, the injuries are simple in nature, full stop. Further, Mr. Lawford submitted that though some empty cartridges were recovered from the place of incident, but there is no evidence as to who fired fired the arms in the place of occurrence. However, he submitted that all the accused petitioners are cooperating in the investigation of this case, and they have already appeared, and their statements were also recorded accordingly. Next, considering the submission made by learned counsel for both sides, made materials on the case record, case diary, vis-a-vis the injury reports of the injured. I find that, and also considering the conduct of the accused petitioners, I find that custodial interrogation may not be required for the interest of the investigation. Accordingly, the order of the interim pre-arrest bail dated 6/12/2024 is hereby made absolute with same terms and conditions. Both the petitions are disposed of.
Problem.
We have not received the CD lordship yet. We
No.
have not received the CD lordship.
Are you on interim here? You are on interim. CD not received, issue reminder. Yes, Lawford, when it can be?
6th of June lordship.
6/6. Interim be extended till next date of list. We are extending our interim.
28.
It also we have not received CD lordship.
Are you here also? Are you on interim?
Lordship. May we continue, Lordship.
Lordship 6/6 lordship.
6/6, then. Same order. Okay, we're listing it on 6/6. Interim will be extended till next date.
29.
29 to who is in? 28,
Here
500
about CD is not updated lordship, so we send it papers.
32. Yes, 29, what is the position?
The CD is not here, sorry, lordship. This is a POCSO matter, lordship.
Oh, it's the POCSO?
Service of notice not completed.
Service is still awaited.
Lordship.
On the last occasion also, service was awaited when we were asked to take instructions, in fact. And otherwise, CD or case diary, what is required? Case diary. Case diary you have already received. It is already retained, I think.
Because otherwise lordship can appoint amicus also.
Hard Mr. You're Mr. A, you're Sigdar.
I'm on behalf of SS Sigdar.
S.S. Sigdar. Your good name?
Yes.
S. Bora. Hard Mr. S. Bora appearing on behalf of Mr. S.H. Sigdar, the counsel for the learned counsel for the petitioner. From the office note, it is seen that the service is still awaited on the respondent number 2. However, this court is of opinion that an amicus may be appointed to represent respondent number 2 accordingly. Mr. S. Nawaz, go to know. Mr. S. Nawaz is hereby appointed as an amicus to represent the respondent number 2. The rest will be needful. CD be retained or you want to what to do?
It will be written, Lordship. otherwise
CD
we
will
will
be
think
retained.
another.
Okay. CD will be retained till next date of listing. List accordingly when it can be listed then.
Okay. On 23rd, Lordship.
20,
23rd.
23rd of May. 23rd. Okay.
31.
Thirty-one, charge sheet is
Certificate, Lordship.
charge sheet submit. Are you on interim there?
No, Lordship, I am not.
You are not on interim. CS number only
76.
76.
of the 25,
Yes,
dated 17/4/25.
17/4/25. So appear before the learned trial court below with an appropriate application for bail.
Lordship, direction may be given to consider my application and enlarge me on bail, Lordship. Direction.
No, that direction cannot be given. It will be in accordance with law. If it or petition is fit, your prayer is considered to be fit, and then definitely it will be allowed. But we cannot direct.
Otherwise, Lordship, actually, I was earlier granted bail by the learned court below. But condition was that I should produce the cash memo for cattle purchasing papers before the IO. But the cattle was actually not purchased. Therefore, I could not comply with that condition. And automatically on the 8th day, the bail was cancelled as per order. Thereafter, I also filed a petition before the learned court below. That was rejected on the ground that the court cannot review its own order. Therefore, I have filed this petition before this honorable court, Lordship.
But now scenario is quite different now. Situation is different because it is already charge sheeted. So we don't have any option. You have to appear. And in that case, if something, this rejection is there, then definitely option is there, you have to appear. But at present, definitely you have to prayer before. Why you have not purchased the cattle?
No, I did not purchase.
From where you have got the cattle?
Actually, I was not involved. On the day of alleged occurrence, I was here in Guwahati. But incident happened in my house, and that was done by my cousin brother due to his marriage purpose, Lordship. A function was there. Therefore, the incident happened. I was not even involved, but happened in my house. That is the problem. And he used his domestic cattle, Lordship. That is the problem. So there is no purchasing papers, Lordship.
Okay.
I have stated everything in my petition, Lordship.
Okay, you appear whatever you see. Yes, okay, then. We dispose your method.
32.
Yes.
This is a bail application, Lordship.
It's the POXO one?
Lordship, section is POXO, Lordship, but for a moment, Lordship, if permit, Lordship, page number 23, Lordship.
You have received the case diary here?
Service not. We have not received a CD as well as the Lordship.
Services completed, he is appearing.
I am appearing for the respondent number 3.
Yes. So services completed. Now you are not, you have not received
got
the
the CD, Lordship, so Lordship may be.
case diary is not received. Is it you require case diary or case record?
It is not charge sheeted, Lordship.
Not yet charge sheet.
Sorted may be given, Lordship.
Your petition is behind the bar since when?
No, Lordship, that is.
Oh, sorry.
Bail,
It's a AB, yes.
POXO may the Lordship CD is required. Lordship.
CD will be required. We cannot pass any order.
Petitioner is a pharmacist. Otherwise, Lordship, the victim is a major, Lordship. I have enclosed the Lordship. Page number 23 for a moment, just Lordship.
No, whatever, we need the case diary.
Lordship.
We don't
Lordship.
pass any order.
Short date, Lordship. Otherwise, the petitioner is a pharmacist, Lordship.
Heard Mr. F. of the learned counsel for the petitioner, and also heard Mr. B.S. Lawford, the learned additional PP, appearing on behalf of state respondent. And Mr. J.C. Bora is appearing for the respondent number 2. It is submitted by Mr. Lawford that his diary not received. Full stop, issue reminder. with the direction to the investigating authority to furnish the case diary on or before the next date of listing. List accordingly when it can be listed. 23/5 or 23.
Obliged, Lordship. Obliged.
33.
Very yes. Unfinished photo is there.
We have received the CD lordship.
There.
May it please, Lordship. Lordship,
You have received the case diary here?
Lordship,
Okay.
I am in
Yes.
interim and
You are on interim.
interim.
Yes.
Co-accused has, the prime accused has been enlarged on bail.
Huh?
Co-accused. Who is the
This
prime
was
accused?
BA.
AB.
In-
AB, both are AB.
So you are on the ground on only for the co-accused. Other ground, you don't have any other ground.
Yeah, main accused has been enlarged on bail.
So main accused is enlarged, so you have to be enlarged.
Yes,
So
Lord.
that is the only ground.
Yes.
Why? You don't have any other case. Otherwise, you are guilty. That means.
Father of the main accused. Should the father, main accused has been enlarged on bail, Lordship.
I don't know why you making submission, such kind of submission. You are the father.
Yes, Lord.
So you got your interim on 1/4.
Yes, one.
You appeared before IO?
Yes, Lord.
Okay.
Nothing was seized from me also, Lord. The victim herself has given the photographs which.
Regarding his involvement, Lordship, that he tried to kidnap her, Lordship. That is the last line of the.
I am the father of the main accused.
Maybe also.
Maybe he is a, but I am not involved here.
He's supporting his.
Father never say to his son to do any crime.
That we cannot say for fathers.
Otherwise, he appeared before the IO?
No, there is no any interim, Lordship.
Huh?
No interim, Lordship.
No, interim is there.
He was an interim.
First of April.
You take it to somebody. You are M. Rahman.
Yes, Lord.
Heard Mr. M. Rahman, the land responsible for the petition, and also heard item number 33. Yeah. And also heard Mr. B. S. Crawford, the land additional PP, appearing on behalf of state respondent. This is an application on section so and so in connection with so and so. CD receipt, where is this? It is submitted by Mr. Rahman that after obtaining the order of interim pre-arrest bill dated 1/04/2025, he appeared before the IO, cooperated in the investigation, and his statement is also recorded by the IO.
It is updated till 20 March also. And it was that happens.
Then we'll extend his interim. Now get to liখিব and so you like this application will liখিব না লাগে. It is submitted by Mr. Lawford that CD is not updated. One, and the last entry in the case diary is only 20/03/2025, and the petitioner was granted with interim pre-arrest bail on 1/4/2025. In view of this, let the updated case diary be called for. List accordingly when
On 10th of June also.
10/6/2025, and interim be extended till next date of listing.
And he said he will appear before the IOS. He will appear before the IOS.
As per his instruction, he already appeared.
Yes,
Okay, then
yes,
further it is the petitioner is hereby directed to appear before the investigating officer if he has not appeared early, and if he has not appeared কি করব statement record করা বলে কয় if his statement is not yet recorded. Then 6.
Obliged.
34.
34 we have not received the CD also. No, LCR. LCR was received also on last occasion. On last occasion, LCR was available, but due to the paucity of time, matter did not reach your lodge. We haven't considered the LCR also. The effect more also mechanism.
You have done control.
Your lordship. I told you it's going on.
Heard Mr. T. Loscott, Ilanet counsel for the petition. Also heard Mr. B.S. Lockhart, Ilanet additional PP appearing on behalf of state respondent. Mr. D.K. Agarwal, you are appearing. Mr. D.K. Agarwal appearing on behalf of the respondent number 2. It is as the request made by the Ilanet additional PP, Mr. Lockhart. List the matter accordingly. Yes, when it can be listed. No, we are not listing any cases on 60. Already fixed matters are there. We have some urgency on 60.
As per convenient cases.
20, 21, 21. Oh,
35.
He's an interim worship.
You have not received the CD.
He's an interim worship.
You are not interim. CD not received. Issue reminder. Interim be extended. Yes, when it can be.
10/6/20.
10/6. Okay, we are listing it on 10/6.
36.
Interim be extended.
Wait, here, my lord, litigation is under section POCSO, madam.
It's a case of FOXO.
We are trying to get it from the morning lordship, but we are not
Oh.
getting service report also.
This notes dated 22/4/2025, my lord.
Huh?
Reflected.
Huh?
Office note dated 22/4/2024, kindly see. ma'am.
Yes, thereafter we don't have any office note also. So you could not take the instructions today.
Since morning lordship, our office is trying, but I is on another duty also. He could not.
Can it be possible by next week, my lord?
Heard Mr. K. Burma, the learned counsel for the petitioner, also heard Mr. B.S. Lawford, the learned additional PP, appearing on behalf of so it is submitted by Mr. Lawford that he could not take the instructions from the jurisdictional police station regarding service of notice on respondent number 2, though several attempts were made by his office. considering his submission, let the matter be listed when it can be. 21. Okay. We're listing it on 21.
CD will be written.
City be written.
37.
May I please, Lordship?
Here also CD is awaited, I think. Oh, no,
My lord, scan copy.
you have already appeared here.
Already, my lord, LCR, scan copy of report LCR has been received. My lord.
Received?
Yes,
Okay, okay.
my lord,
Scan copy is received, law court have begun by other, they have not also gone.
my lord, FIR is at page 10, my
No,
lord.
just a minute. Today to, this week will not be possible. 15, we have some civil matters and 16th also we are not fixing. It will be obviously either 20, 21 or 22 at best.
22, my lord, that is.
22.
Yes.
Heard Mr. A. Hussain, the learned counsel for the petitioner, and also heard Mr. B.S. Lawcourt, the learned additional PP, appearing on behalf of state respondent. You are Mr. A.S.
Respondent number 2. A.S. Chaudhary.
A.S. Chaudhary, Mr. A.S. Chaudhary, appearing on behalf of the respondent number 2. And the request made by the learned additional BP, matter be listed on 22nd, 22nd May. Scan copy of the LCR has already been received, and I see already. 2022 we have filed.
38.
Yes, Harshit submitted, Lordship.
Are you on interim there? Earlier interim was there?
Before I will.
Statement recorded. Okay. So then we are extending your interim till 15 days from here. So yes, CS number, yes.
20/25.
20/25.
31/3/25.
31/3/25. So on the day of granting interim was actually, charge sheet was already filed. Because we granted interim on 11/4. Yes.
Already.
20/25, 31/3/2020. We're extending your interim till 15 days from the date of order. Appear and with a regular bail application before you land a trial.
Problem.
39.
Here also, Lordship, CD we have received, but it is not updated, Lordship. Last entry is, Lordship.
Last
5/5/25.
5/5?
But interim given on 14/5/25, so it is not updated, Lordship.
No, no. No, no. 11/4/2025.
11.
Then it is updated only.
But it is his statement is not here.
I have appeared before the I have the acknowledgement also. But
Now interim was granted most probably on 11/4/2025. 11/4. And your last entry is 5/5.
5/5/25, but his statement is not here, Lordship.
5/5/25 then to,
I have appeared on 17/4.
but your statement is not available.
So may call for the update case.
You have appeared, but your statement is also recorded
Yes.
there
Statement is
as per instructions. Your statement
Yes.
recorded. This is not here only.
Yes.
Okay, you are Mr.
Thank you.
Heard Mr. H. Agarwal, the learned counsel for the petitioner, and also heard Mr. B.S. Lawcourt, the learned additional PP, appearing on behalf of state respondent. It is submitted by Mr. Lawcourt that the case diary received, but the statement of the present petitioner is not available in the case diary. So in that context, Mr. Agarwal has submitted that learned counsel for the petitioner has submitted that as per his instructions, the petitioner has already appeared before the IO and his statement is also recorded by the IO. Now, let a updated case diary be called for and with a direction to the IO to furnish the statement of the accused petitioner if already recorded. And further, the petitioner is also hereby. Now, your petitioner is
Already, I have
recorded.
my record. If it is not, if suppose it is not recorded, I will call anytime we are ready to cooperate. Your lordship may not indicate it.
However, if this statement is not yet recorded, the petitioner is hereby directed to appear.
As and
And
when called for.
Huh?
As and when called for by the hour.
no, as a when call for is not there. Your statement is not available with us.
I have instruction that.
On which date? As per your instruction?
17/4/2025.
17/4. Make a mid date to Likhidok 17/4. Okay, we are lifting it 17/4. Recorded to the CD call for along with the statement of the present petitioner, if any. Okay. When it can be listed?
On 6/6.
6/6.
Public.
14.
Seriously,
It's available. So FR in page 8, my lord.
FR is at page
8. Stated that on 2/4/25 at about 5 p.m. my minor daughter Afsana Khatun, aged 16 years, came to shop from house. The below named
Is there any addition of POXO and all?
eloped my daughter forcefully. Our case is that I have not eloped.
Addition of section, any section of POXO? No.
no.
So my
It's a case of basically kidnapping.
that is the-
Yes, what is the submission? Yes.
my lord, my son.
You are the
My lord. I am the petitioner, my lord, Anisur Rahman, my lord. I have stated in para 5, my lord, the actual fact of the case of the my lord.
yes.
Girl is minor. The proposal is going on between my family and the victim's family, my lord. For marriage, as girl is minor, so my family asked them to wait for 2 years. But said girl victim has love affairs with another girl, another boy, my lord, and she eloped with that boy. But the apprehension of the informant apprehension is that I may not be married, my lord, after 2 years, and that is why just to compel my lord, compel me. My name is incorporated in the FIR, counseling the.
So you had love affairs with the.
No, my lord.
You
Another boy. There was a proposal between two families, my lord.
No, who are you? You are the main accused, your
No.
father, mother, who are you?
My lord, I am named FIR, named accused, my lord. That is revealed in the city, my lord.
Lordship, in 183 statement, she stated that there is a love relationship between them, Lordship, and this petitioner, Lordship, on that day, forcefully took her in his bike and took her to his sister place. And on that night, they stayed there. And next morning, the girl went up. Lordship.
But now I'm asking is there any physical allegation of physical relation? No. Heard Mr.
M.
Hussain, the counsel for the petitioner, and also heard MS Andas, the line of additional PP appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. CD receipt, parents receipt. Next paragraph, it is submitted by Mr. Hussain, the counsel for the petition, that he is innocent and has not committed any such offense as alleged in the FIR. First. It is the fact that there was a proposal of marriage between the present petitioner and the victim But as the victim had not attained her majority, they postponed the marriage proposal. In the meantime, she eloped with another boy, and only to compel to marry the present victim, an affair has been lodged against him with some false and concocted allegations. However, he is ready and willing to cooperate the IO and so and so and so. Next for MS does the learned additional PP submitted in this regard. That as per the statement of the victim, she had love affairs with the present accused petitioner, and she also eloped with the boy and stayed with him in a house of sister of the present petitioner. However, she did not brought any allegation of physical relationship between them. MS does accordingly submitted that the petition may not be considered at this stage, as there is implications against the present petitioner. Next paragraph, considering this submission made by learned counsel for both sides, materials available in the case diary, I find that custodial interrogation of the present petitioner may not be required for the interest of the investigation. Okay, you will be granted with the pre-arrest bail. There will be some terms and conditions, abide by all the terms and conditions.
Okay.
41.
May I please, your lordship?
Here we received the case diary.
Your lordship, in the instant matter, petitioner number 1 has already been arrested, your lordship, and therefore petitioner number 1 will turn infractuous, your lordship. For a
Petitioner number 1 arrested.
has been arrested, your lordship. Petitioner number 2 and 3 have not been arrested. Moreover, your lordship, POXO matter, your lordship.
Services awaited here. Who is appearing?
Services are not completed. No one is appearing. Amicus may be appointed also.
Others we have received the case diary. So what do you want? You want to retain what that one, case diary?
Lordship, I can.
You have to
send it.
retain, otherwise.
Shorted, Lordship.
Heard Mr. T. Laskar, the learned counsel for the petitioner. We also heard MS Endas, so and so. CD received. But it is seen from the office note dated 1/5/2025 that the service is still awaited for the respondent number 2. In view of this, let an amicus, I find it, this court is of opinion that amicus may be appointed to represent the respondent number 2. Accordingly, A. Fukan. MS or Mr. A. Fukan is hereby appointed as an amicus to represent the respondent number 2. Registry will load in needful. List accordingly when it can be listed then. 27/5.
For filing bail application, your lordship.
Sorry. That's what Corvo. So and so list to be sorted. Further, it is submitted by Mr. Laskar that the petitioner number 1 is already arrested in connection with this case, and hence he doesn't want to press the petition for the petitioner number 1, as the petition has already become infructuous in respect of the petitioner number 1. List accordingly, it will be listed on 27, you are saying? 27. Till then, CD be retained. We are retaining the case diary.
54 of the supply list.
ওলাই আছে নেকি আৰু আছে Oh, here we have not taken steps, na?
CD not received.
There is some fault on my part, I will take steps.
You're going to take,
And CD
okay.
has also not been received.
CD was. Otherwise, CD was called for, na?
Yes, otherwise CD was called.
CD not received.
CD not received.
But Mr. A. Hussain.
Lordship, CS submitted.
Oh, acha.
CS submitted.
CS submitted.
2220.
Okay. Yes, CS number.
CS number 13 of 25, dated 20/2/25.
13 of 25, 22, 25.
Long back it, such it has been filed
Hmm.
prior to filing of this.
Yes, obviously, but why it was
Yes.
not brought, I don't know.
Yes, ma'am.
Anyway, you have to approach before the learned trial court below with an application for. Otherwise, we are disposing your petition.
For others, item number 42, 43, and 44.
Madam, can it be taken up at the last item? So
This is the last item.
46 is the right.
No, this is the last item. Let it be what to do. He can submit, you can take up the petition. Because on the last occasion, most probably there was a direction that you have
Yes,
to.
yes,
appeal.
we'll commence the hearing.
So in 42, 42 is an IA.
42, 43, 44, 3 IAs I have filed.
So these are all IAs. No, but 40, 40,
All IAs.
43.
All IAs.
Why all IAs means when 43. Mr. Ken Chaudhary is there for 43.
All, he's there for all.
In all the matters.
Let's forget about IA where in the read petition, who are the petitioner? In read petition, you are the petitioner.
In all, Mr. Ken Chaudhary is leading us.
Yes,
So
you are the petitioner.
petitioner, first is Hitesh Barua, second is M. Kumar Barua, third is Dharani Barua.
Oh, yes.
These are
This
the-
connection with one hospital, I think, one.
Yes.
It is in connection with regarding a particular FIR which was lodged by the CBI. It was in that connection. So they have filed an IA for vacation of stay.
So particularly 42 is the vacation of stay.
No, all I.
All.
Acha,
acha.
all. Basically, one will cover everything.
Yes. I'm just taking up lordship IA 372 in WP criminal 13.
Yes, IA 372, yes.
372. Now, lordship, this is a case of money laundering. And the predicate offense was registered by the CBI. And the petitioner herein was summoned under section 50 of the Prevention of Money Laundering Act. If I may just read out section 50, lordship, for a minute. Now, basically it's on the same. Lordship will argue only one because it's the same case, lordship. Otherwise, we have issued a summon, they have challenged it, and there was a stay. Now we have filed an application in all the three cases for
Vacation of the stay.
vacation of the stay. Now, the matter starts with issuance of a summon to all the under section 50. The power of issuing summons is under section 50 of the PMLA. Now, this is, I'm just reading.
Yes, sorry.
Huh?
Yes.
Powers of authorities regarding summons, production of documents, and to give evidence, etc. 1. The director for the purposes of section 13 shall have the same powers as are vested in a civil court. According to the civil procedure, while trying a suit in respect of the following matters: discovery and inspection, enforcing attendance of any person, including any officer of a reporting entity, and examining him on oath, compelling the production of records, receiving evidence on affidavits, issuing commissions for examination of witness and documents, and any other matter which may be prescribed.
Two, the director, additional director, joint director, deputy director, or assistant director shall have the power to summon any person whose attendance he considers necessary, whether to give evidence or to produce any record during the course of investigation or proceeding under this act. All the persons so summoned shall be bound to attend in person or through authorized agents as such officers may direct, and shall be bound to state the truth upon any subject respecting which they are examined or make statement and produce such documents as may be required. And every proceeding under subsection 2 and 3 shall be deemed to be a judicial proceeding. Now, here, Lordship, case was registered by the CBI, which happens to be the predicate office, because there has to be a predicate office first. There has to be an FIR from which the information is taken by the Enforcement Directorate and it makes its own ECIR. ECIR is an official document. It is the source of the information. What is the information? And thereafter, summons have been issued to the three petitioners, which is under challenge in the main petitions here. Now, if I may take your Lordship to my affidavit, to my IA 372.
Yes, page number.
I may take your Lordship to page 27. 26, it starts from 26. The initial facts are there in 27. Now, if I may take your Lordship to page 28. Second from, I'm reading from the second paragraph, Lordship, page 28. Notwithstanding the same, a first information report was lodged by the CBI, Anti-Corruption Bureau, Shillong, alleging misuse of fund provided by NEC by the petitioner. On such basis of such FIR, number so-and-so was registered under section 120B 420, read with section 13(2) and so-and-so of the PC Act. Petitioner has assailed lodging of the first information against him before this court in WP Criminal 6 of 18. This court, by order dated 20/08/2018, directed maintenance of status quo insofar as investigation against the petitioner was concerned. It is submitted that this order has been extended from time to time and still holds the field. Notwithstanding the above, Assistant Director, Enforcement Directorate issued summons to the petitioner under subsection 2 and 3 of section 50 of the PMLA. I've just read it. To appear before him on 19/7/2019 to tender evidence. It is submitted that on such an application by the petitioner, date of appearance has been deferred. Mr. Chaudhary, learned senior counsel for the petitioner, has referred to subsection 4 of section 50 of Money Laundering Act and submits that every proceeding under subsection 2(3) of section 50 shall be deemed to be a judicial proceeding within the meaning of section 193 and 228 IPC. Therefore, any statement made by the petitioner before the assistant director would be constituted to be evidence and may be used against the petitioner. It will be against the principle of self-incrimination, against which the petitioner has a fundamental right under Article 23 of the Constitution. That apart, he submits that when the investigation into the scheduled offense has been stayed by this court, there cannot be a parallel and independent proceeding by the Enforcement Directorate. The horse investigation into the scheduled offense. So-and-so Central Government Council submits that since the petition has been granted sufficient time by the Assistant Director, she may be granted time to obtain instructions, and in the meantime, no interim order may be passed. After hearing the counsel for the parties and due consideration, this court is of the view that the matter requires further scrutiny of the court. Issue notice so-and-so, having regard to the above impugned summons issued to the petitioner by so-and-so, and any subsequent summons on similar lines to the petitioner shall remain stayed. Now, the order of status quo, or let us say stay, was passed in WP Criminal 6 of 18. Your Lordship has noted that is in the third paragraph of page 28. Now, they have withdrawn this case. The petitioners have withdrawn this case. Your Lordship will find that order in page 30. In page 30, Lordship has found. And the operative portion, Lordship will find at page 32. On the prayer being made by Mr. N. Gautam, learned counsel appearing for Mr. K. N. Chaudhary, so and so, these matters stands disposed of on withdrawal. Therefore, as on date, there is no stay order. As on date, there is no stay order after the withdrawal of this. It pertains to all the three cases. In that view of the matter, actually, by reference to this order, there is actually no stay. We can proceed in the matter. Since they have withdrawn the main case. However, as an abundant caution, Lordship,
All the matters were withdrawn, no?
withdrawn, Lordship.
No, slight correction in this thing. In item number 42 had preferred this WPC criminal along with two other accused, wherein in other two accused that are mentioned, they had not preferred anything. So they are not even the accused person, the other two are not even the accused. There's a slight complication of facts, so which need to be, let him address, then I'll address the thing.
Address that also. I'll address that also. Now, your Lordship will come to section 3 of the PMLA.
But this order of withdrawal was passed on WPC criminal
Lordship
6/2018. Here as well.
withdrawal
6/2018.
Yes, based on WP 6, they got the stay in the other two cases as well. They had shown the same order in the other two cases and they had got a stay. Now, they have withdrawn it. So therefore, the main case, that is gone, Lordship. And so far, if my friend says that he was not an accused, in the predicate office, let us see section 3 of the PMLA, Lordship.
No, your main contention is that those TWP criminal were already withdrawn. Then at present, what is the cases now?
Oh, confused.
Just confusing, that's why you have said that.
If I may just clear up this thing, what has happened is that an FIR was lodged against Hitesh Barua, Nawazdi Sharma, and and two persons, Hitesh Barua, in the capacity of MD of Nemcare. That is very important. The capacity of MD of Nemcare, and Nawazdi Sharma in the capacity of being the DDM finance officer of NEC. So FIR was lodged by the CBI. What had happened is that after the lodging of the FIR, we had come before the Honorable Mr. Hitesh Barua had come before the Honorable Court. Honorable Court stayed the proceeding. Similarly, Nawazdi Sharma's proceeding was also stayed. Thereafter, ED issued notice. Then Hitesh Barua approached this court first, the first petitioner. He approached the court first, and a stay order was given in this particular case. No, the stay order clearly talks about giving the stay based on the grounds of 23 and on the ground of WBC 6/13, which Hitesh Burua had preferred being stayed. That was the ground. Thereafter, the other two petitioners also approached the court because they also got the summon and their stay was there. So that is the factual background regarding this. Then this case was, there was nothing was happening in this case. Then after the withdrawal of the case by Hitesh Burua, that is in the petitioner, that is, then this IA was filed seeking that the vacation, the order should be vacated. So this is where the where gets submitted. That is the.
Now, so far as investigation in a PMLA case is concerned, it is not limited to the accused. It is not limited to the accused. Why? Because Lordship will see section 3 of the PMLA for a moment.
Yes.
Whoever directly or indirectly attempts to indulge or knowingly assists, Lordship will knowingly assists or knowingly is a party or is actually involved in any process or activity connected with the proceeds of the crime, including its concealment, possession, acquisition, or use and projecting or claiming it as untainted property, shall be guilty of offense of money laundering. He need not be the first person himself. Because what happens is a person would, let us assume he would get some money. In this particular case, he got some money through some means from the NEC. He is not a named accused, but he might be concealing it. He might be transferring it, making some other assets. Now, in whoever's possession it is, or whoever conceals also, he is also a party to be investigated under the PMLA. It is not necessary that only the accused, it will be limited only to the accused in the FIR. Now, so far as section 50 is concerned, section 50, your Lordship has noted, it confers the powers of a civil court. And the Supreme Court, in the landmark decision of Vijay Madan Lal, has upheld its validity. It is not the ground of self-incrimination under Article 20. The Supreme Court says, no, it is not that, because it is only an inquiry. It is only an inquiry made. And the validity of section 50 has been upheld by the Supreme Court in Vijay Madan Lal. Therefore, he cannot come and say now that it will adversely affect me. The ground which he has taken, that it will be amount to self-incriminating, that is no longer there in view of the Supreme Court's decision in Vijay Madan Lal. In that view of the matter, Lordship, since final disposal no haja.
So I just ask you, is it a final disposal or only on stay? I don't know.
I
think ideally Lordship should dispose of the, whole matter.
Because of peculiar circumstances
Ah.
of this case, which is not covering all the judgments in that all the judgments are there. Just regarding
My lord,
those things.
I'll satisfy your lordships. They're proceeding on non-existent facts.
That's
Even the charge sheet, from the charge sheet, I will prove it. I think I can start, my lord, if your lordship gives me the permission. I think same amount of effort will be required, whether it is for stay or for final disposal.
Let him start, Lordship. I do not have a contradiction.
Okay then. If finally dispose of it, it will definitely help.
Yes.
Mr.
Today, I'll start, my lord. It will take some time. Your lordship will kindly give me that liberty. If your lordship would kindly take item number, criminal petition number 13 of 19. First item.
First time.
Yes.
Now, what had happened, my lord?
13.
Lordship knows in the GS Road, there is a hospital called Nimcare Hospital. And there is an unit called Burn Care Unit. Now, my lord, for development of that Burn Care Unit, some grant was given by NEC. And that is the subject matter. Now, my lord, I don't understand why I will resort to my own thing, my lord. It's a money which I have purchased for my own development. Where is the question of, my lord, misappropriating or anything? If a lordship would kindly first come to page number 48, my lord. This all started with this application at page 48. Kindly see the, my lord, subject, proposal for establishment of modern burn care center at Guwahati. Now, my lord, the estimate which we gave was at page 50, is at page 50. It was given, my lord, 58. It was in 2006, my lord. Our total estimate was 58 lakhs 86,000. Then, my lord, will kindly come to the detailed project report which was submitted, which is at page number 58. Now, I'll have your lordship's kind attention to page 59. If your lordship would kindly come to page 59, line about 8 from the top, sentence starting with Burn Care Foundation, as your lordship got in. Burn Care Foundation is the first organization in the entire northeastern region which came up with its unique proposition of establishing a dedicated burn care unit. The unit has joined hands with Nimcare Hospital for technical support to treat burn patients. The hospital has also provided a space to the foundation to accommodate the patients. This has been done on a mutually agreed terms and the Burn Care Foundation. Then my lord will kindly come to next page, page 60, upgradation. Currently, Nimcare Hospital is operating a 65 bed multi-speciality setup. It has 2 major operation theatre, 1 minor theatre. The hospital has provided 6 beds and a dedicated theatre exclusively for burns. So when we applied for this grant, my lord, apart from anything else, we had 6 dedicated beds for treatment of burn care. Then my lord will kindly come to the last 4 lines. This unit, though fully independent, will have to depend on hospital for allied services and experts who would give their necessary advices for treatment of the patient. This unit means, my lord, the burn care unit. This would also help to act in synergy with the hospital for delivering quality care to the burn patient. Then my lord will kindly come to page number 66. Now, the project cost was, my lord, total was 10 crore, of which purchase of equipment and OT structure is 3 crore. Second line. So, my lord, the project report envisages that total project cost would be 10 crore, and for purchase of equipment and operation theatre structure, the cost involved would be 3 crore. Then, my lord, there was a revised project report which was submitted at page 68. And I'll have your lordship's kind attention to page 69. Last 4 sentences towards the bottom. Burn Care Foundation is the pioneer in introduction of modern burn care facilities in the entire northeastern region. The unit's clinical division is located in the first floor of the Nimcare Hospital. As per mutually agreed terms, the clinical part will remain inside Nimcare Hospital till construction of an independent burn unit. Then Milord will kindly come to page number 81.
Yes.
Now, page 81, conclusion. Now, I'll have your lordship's kind attention to the subpara. The foundation had earlier sought 10 crore from the government. Has your lordship got it? Yes. The foundation had earlier sought 10 crore from the government sector. Due to vision of the project, some eminent personalities and organizations of this region have shown their interest to support the activities of the unit. And because of an urgent need to venture into field of burn, all these eminent personalities have come forward to help in building the project on a bigger scale. The facilities and provisions as given in the earlier report has been scaled up, and also some more facility have been incorporated to make the Burn Care Foundation a full-fledged state-of-art unit in the entire northeastern region. This has resulted in the slight increase in the project cost. The detailed project report has been prepared, and total cost of the project has come out to actually basically 23 crore. Earlier it was 10 crore. Now, there is a letter at page 96, whereby there is a sanction. Now, they never acted on the revised DPR. They acted on the first DPR, my lord, of 10 crore. Now, NEC is writing to my lord, advisor, NEC. In inviting reference to the subject quoted above, I am directed to enclose herewith a letter from the Secretary Burn Care Foundation, Guwahati. The trust has agreed to bear 10% of the loan component of the scheme. I am further directed to inform you that Government of Assam has agreed on the undertaking of Messrs. Burn Care Foundation, Guwahati to provide 10% loan component of the scheme. Now, actually, I should have read page 97 first, then 96. Now, please come to page 97. This is the sanction letter by NEC. Anyway, establishment of modern burn care center, Nimcare. Secretary NEC, in exercise of financial powers authorized by the Government of India, Ministry of Home Affairs, by their letter dated so and so, is hereby accorded administrative approval of 300 lakhs towards expenditure on plan schemes for establishment of a modern burn care center at Nimcare Hospital, Guwahati during the year 2008-2009. Now, I'll not read the whole page. Of course, I read to para 2. Out of the above approved amount of 300 lakhs, that is 3 crore, NEC will support, NEC support will be restricted to 90% grant, and that is 2 crore 70 lakhs, and the loan component 10% only shall be provided by the state government. My lord, in the initial project report of 10 crore, Lordship has seen this component of 3 crore was for, my lord, equipments and operation theatre structure. But we also prayed for loan for other things so that we can set up an independent unit. Since loan component was confined to only equipments and operation theatre structure, therefore, my lord, there was no question of setting up separate hospital. What we did in Nimcare Hospital itself, we have developed that Burn Care Foundation. Now, out of this 2 or 3 crore, 30% Government of Assam was supposed to pay. Government of Assam did not pay. Therefore, we ourselves paid that. That you will get, Lordship will get at para 5. Para 5. 10% loan component of rupees 10 lakh only shall be provided by the state government of Assam towards the project against grants in aid sanctioned by NEC. in terms of Government of India's acceptance of the recommendation made by the 12th Finance Commission. Now, my lord, I'll trouble your lordships to come back to page 9. Huh? Please come to on the page 96 for a moment, my lord. Now, the component of the 10%, that is 30 lakhs, which was supposed to be paid by the state government, we all know, my lord, the financial constraint of the state. Therefore, this letter is written within the NEC. In inviting reference to the subject quoted above, I am directed to enclose herewith a letter from the Secretary, Barncare Foundation. Trust has agreed to bear 10% loan component of this scheme. That means, my lord, the 30% was paid by us. So, in effect, we received 2.7 crore. And I'll show, my lord, how we have utilized the whole amount. Now, my lord will kindly come to page number 99. This has a reference to this office letter dated 26th of February, whereby according administrative approval for an amount of rupees 300 lakhs and sanction of 90 lakh during the financial year 2008 and 9 towards the above mentioned scheme. In this connection, you are hereby requested to kindly constitute a technical committee and a purchase committee for procurement of equipments, etc. An advisor held NEC may be inducted as a member in the purchase committee. So, my lord, this was written by advisor to the Secretary, Barncare Foundation, whereby, my lord, it was directed that a purchase committee should be constituted, and in the purchase committee, amongst others, the member, advisor health of NEC may be inducted as a member. Then, my lord, will kindly come to next page. This is my Government of Assam in the Health and Family Welfare Department. I have the honor to forward herewith a letter with enclosures received from Secretary, Barncare Foundation, white letter dated so-and-so, regarding nomination of a member of Purchase Committee constituted by Secretary, Barncare, Guwahati. OSD of this directorate is nominated as a member of the Purchase Committee constituted by Secretary. So, my lord, Government of Assam's nominee was the OSD. Then, my lord, at page number 101, the minutes. Please come to the last three sentences, my lord. The technical committee and purchase committee constituted by authorities of Barncare on the advice of NEC advisor has already scrutinized the specifications, quality and rate of various equipments that are to be procured by foundation and has given the recommendation for purchase. In this context, I would like to inform you that NEC has accorded an amount administrative approval of 300 lakhs so-and-so for purchase of equipment machineries for Barncare unit in the Barncare Foundation, Guwahati, and out of this NEC has sanctioned an amount of 90 lakh. This was the first tranche during the year so-and-so, so-and-so. As expressed earlier, Barncare Foundation is ready to bear 10% of the loan component of the administrative approval by NEC, and the Government of Assam white letter has agreed on the undertaking of Barncare Foundation to provide 10% of the loan component. The total cost of the equipments for the first purchase is 1,11,590. I request you kindly to release the first sanction amount of 90 lakhs for implementation of the project. Then, my lord, will kindly come to page number 153. Now, after all observing all these formalities, this first tranche is sanctioned. I am directed to convey the sanction of the Governor of Assam for an expenditure not exceeding 90 lakhs, only as grants in aid against a scheme establishment of modern burn care center by Burn Care Foundation, Guwahati, etc., etc. The above sanction is issued subject to the condition that DME, that is Director of Medical Education, will verify and satisfy himself about reasonableness of the rates before release of fund. Now then one para thereafter, utilization certificate to all concerned should be submitted in due course. So my lord, sanction letter envisages two conditions, that the sanction is subject to condition that DME will verify and satisfy himself about reasonableness of the rate, etc. And utilization certificate has to be submitted. Now, if at all, my lord, we have purchased things at inflated rate, then DME also should have been an accused. What a silly thing, my lord. Then, my lord, will kindly come to page number 155. This is the utilization certificate. Submission of utilization certificate and physical and financial progress. With reference to your letter and subject cited above, I am submitting herewith utilization certificate and physical and financial progress report under the revenue head so and so. So as per so page 156 to my lord, 157, these are all utilization certificate. Now, my lord, there is a process. I may just indicate, lordship may kindly take note of that. First step is sanctioned by NEC. NEC will sanction the amount. Then second step is, my lord, finalization of equipments by the purchase committee. Purchase committee. Then third step is submission of minutes of purchase committee to DME Assam, on whose recommendation disbursement is made by Health Department. So purchase committee will submit the minutes to DME, then he will recommend disbursement to the Health Department. Then last stage is, my lord, submission of utilization certificate. So this money I cannot spend of my own. The DME will satisfy himself about reasonableness of the rate, etc. Then, based on purchase committee's recommendation, DME will ask the Health Department to make the disbursement, and after disbursement, there will be utilization certificate. So, my lord, by following this process, the first tranche was over. Then, my lord, please come to page number 172, sorry, 158. This is regarding minutes of the technical committee in respect of the second installment. 158. It starts from 158, my lord, and it ends at page number 171. Then eventually, my lord, the sanction regarding the second tranche is at page 172. Secretary NEC, in exercise of the financial power authorized by Government of India, etc., is hereby accord sanction for release of 100 lakh, only being the second installment, and as 90% grant to the Government of Assam
towards NEC scheme, establishment of modern burn care center by Foundation Guwahati during so-and-so. So this is regarding my second stance. Then at page number 170, 197, Milord. This sanction. Now, before this process, Milord, the technical committee, purchase committee, DME, all got together. Then the health department is releasing this money. I am directed to convey the sanction of the governor of Assam for expenditure not exceeding 100 lakhs. So, Milord, sum and substance, this second tranche was also for 100 lakhs, out of which 90% will be paid by NEC and 10% will be given by the petitioner. Now, utilization certificate in respect of the second tranche is at page number 198. Submission of utilization certificate in respect of NEC scheme during the year 2010-11. With reference to your letter subject cited above, I am submitting utilization. So regarding second tranche also, Milord, utilization certificate was given to the NEC. Then, Milord, there was an inspection done by the NEC authority, Milord, which your lordships will find at page number, sorry, before that, my lord, I must place one page. Page 209, I'm sorry. Now it is an intra-departmental communication of NEC, Milord. In inviting reference to the letter on the subject quoted above, I am directed to enclose herewith utilization certificate of rupees 219 lakhs against NEC funded scheme under health sector for favor of your kind information. So until now, there is no problem. Everything is going on smoothly. Then Milord will kindly come to page number 20210. This is an inspection report, is very important. In response to the letter dated 24th October 2011 of the NEC, the Director of Medical Education Assam directed committee constituted by this letter dated so-and-so to go for on-the-spot inspection of burn care unit at Nimcare Hospital, along with nominee of Northeastern Council. As per the office order of the Director of Medical Education Assam, the following members of the committee comprising of P.K. Oza, P.P. Day, Simoti K. Soikia, along with Jain Sharma consultant, NEC visited Burn Care Foundation at Nimcare Hospital on 25th of October at 11 a.m. for inspection of the burn care unit at Nimcare Hospital, Guwahati. At the outset, an overview of the establishment and functioning of the Burn Care Foundation was briefed by the Managing Director of the Burn Care Foundation. After some interactions with the team of doctors of the Burn Care Center, the committee went round the hospital for physical verification and took stock of the equipments procured and installed from the NEC fund. The committee observed the following: 4 beds earmarked for burn care patients and 2-bedded ICU for burn patient in the hospital have been seen. Equipment including an ambulance furnished as so-and-so as approved by NEC were found installed in the center, except one ultrasound machine for which orders have been placed as informed by the Secretary Burn Care Foundation. As per MOU with the Government of Assam, the following services are to be rendered by Burn Care Foundation. For BPL person, 30% bed, free accommodation including ICU, doctors and nurse free, etc. These are the conditions. The necessary records were verified and detailed reports on the number of BPL patients treated by burn care from 2005 to 11 up to 11 sector has been collected and furnished below. So, my lord, this was the findings. Then, my lord, will kindly come to page 212. List of equipments under NEC scheme for establishment of modern burn care unit, burn foundation. My lord, as on this date, out of 2.9 crore, 2.19 crore, 2.19 crore is there. Look, somebody feel, well, at end of the day, Nimcare Hospital, Milord, basically, the purpose of this grant is some common people are getting the benefit. We cannot charge from this some people. One who is below poverty line, one who is below some income. That is the benefit. Then, Milord, there was so that inspection report was gone. Now, my lord, there was a third installment. That minutes of the third committee, third installment is at page 222. Oh, 13. Oh. There is one more part, my lord. I'm sorry. At page 213.
Yes.
Now, my lord, at page 213, I'll read from this subpara. Before the physical inspection by the team, a small review meeting was held in the office chamber of the managing director. Dr. So-and-so welcome all the members of the inspection team and gave an overview of the activities of the Burn Care Foundation, which includes not only to provide special treatment to the burn injured patient in the hospital where so-and-so patients, but carrying out public awareness program in Guwahati about the prevention of burn accident. Then, Milord, may kindly skip this. Kindly come to the last 5 sentences of the main paragraph. He further appreciated the role of NEC in providing fund to the Burn Care Foundation for its upliftment and informed that most of the essential equipments, including ambulance, have been procured from the fund already received. That is so-and-so, except the portable ultrasound costing 14 lakhs, for which supply order has been placed by them. List of equipments already procured and enclosed in so-and-so. So this is the part of the report. Then please come to para 214, Milord. Page 214. The inspection of the hospital then concluded with the note that Burn Care Foundation has been able to provide specialized treatment to the burn patients of the Northeast with its limited capacity by properly utilizing the NEC fund and has capacity to grow in future with its dedicated team of doctors and paramedics who have been trained specifically in the field of burn case treatment. So this was the report of the advisor health of NEC. Then Milord will kindly come to page 222. This is regarding the third tranche. Now, I'll not trouble your lordship much. Lordship will kindly take note. Page 222, the minutes of the technical committee meeting held on 10/12/11 regarding the third tranche. And my lord, the letter of the advisor of the NEC according sanction is at 259. So lordships may kindly come to now page 259. Same procedure, my lord. The DME, health department, everybody got together. Secretary NEC in exercise of the financial power authorized by the Government of India, Ministry of Home Affairs, by the letter dated so-and-so, hereby accorded sanction for release of 80 lakhs, only being the third installment of the so-and-so. And as 90% grant to the Government of Assam. So, my lord, it has to be 270. Earlier it was 190. Now this 80, so it makes, my lord, 270. And 30 is from our side. And my lord, minutes of the purchase committee is at page 261, 262. Then my lord, page 320, petitioner writes to the DME for release of the final installment, page 230, 320. So, my lord, the barn care is writing to the DME for release of the third tranche. Then, my lord, at page number, there was some in between communication, which we are not very concerned. Then at page 327, my lord, this sanctioned by the NEC. (327). In between, there are some communications, my lord, which are not very relevant. This is to invite a reference to your letter dated 14th of August 12, submitting therewith details in response to our letter of even number. In this connection, I am directed to convey approval of the competent authority for procurement and installation of a DG set amounting to Iman, approved by the so-and-so, and purchase committee amounting to so-and-so, and within the item of works approved by NEC earlier. However, it may be noted that any additional amount over and above so-and-so would be borne by the foundation authority. It is so-and-so, so-and-so. Then, my lord, please come to page number 328. It is a part of the audit report by the office of the AG. In continuation of this department's letter on the subject cited above, I have the honor to enclose herewith audit certificate on expenditure incurred under major head so-and-so grant number 44 for implementation of the NEC schemes during the year 2008 to 2012, received from Senior Audit Officer, Office of the Principal AG, while later dated so. Then, my lord, please come to page number 330. Now, this is the audit report of the Office of the Accountant General. Head of account and name of the specific scheme, so-and-so, so-and-so, establishment of burn care center at Nimcare Hospital, Guwahati. Total expenditure, last column, my lord, total expenditure admitted in audit 2 lakh crore 70,000. Then, my lord, will kindly come to page number 339. Actually, what happened, my lord? Regarding the third tranche, the Assam government, committed some delay in sending the utilization certificate. That is what prompted, my lord, some very over-enthusiastic officials of NEC, my lord, and we know him, my lord, no point naming him. Page number 339. This I must read, my lord. Not a very long one. Tour note of Dr. Bamin Tada. That this is he is also an advisor health. Earlier one Jain Sharma was there. Now is another person. Secretary for the month of so-and-so, so-and-so. The team consisted of all these personnel, my lord, Bamin Tada, etc., etc. I, along with Dr. K.K. Bormon, RMO, and the above mentioned officials of Burn Care Foundation, inspected the NEC projected burn care unit and found 3-bedded burn care unit well equipped with ventilators, monitors and other accessories. Out of 3, 1 was occupied by a 60% burn injury patient. Another was kept ready for recovery and post-operative cases. The nursing station was inspected and was found to be a bit congested. It was discussed with the management group of the BCF for improvement. A total of 17 nurses are earmarked for burn care unit, which is 1:1 pre-shift, 8 hours with 15% leave service, which is quite adequate. Nurses are trained to handle burn care patient. Adjacent to the burn unit is the operation theater, which is absolutely meant for burn care with all equipments and accessories purchased with NEC fund. All equipments are functional condition. 3 burn care unit beds, which were furnished with the ventilators and monitors, were procured under the NEC fund. I also inspected the DG set laundry unit purchased under NEC fund. As such, no fraud was diverted, no fund was diverted for civil construction of the Nimcare hospital. After thorough inspection of the hospital, it was found that sufficient staff and trained doctors are in position. Well, these are the report of the NEC. Then, my lord, at page 344, there is a report. Virtually, it says that project is implemented, therefore there is nothing survives. Page 344, it is again by NEC. In view of the delayed completion of the project for more than 5 years from the scheduled date of completion of the project for establishment, as sanctioned by the administrative approval, at an estimated cost of so is hereby declared as closed. The targeted date of completion of the project was so NEC had released its entire fund in 3 installments, including NAS last installment released on so. Government of Assam must submit the pending UC. This is the point, Miller. The government of Assam must submit the pending utilization certificate of 80 lakhs and 0.21 lakhs up to the date of physical and financial progress report, and latest for the photograph of the project to be NEC within 15 days, etc. So, my lord, from the point of view of NEC, the project was considered as complete and closed. Only thing that was left was that utilization certificate for this 3rd tranche, by which, my lord, they called upon the government of Assam to lodge it. Then, my lord, this FIR was lodged at page 345. I'll come to the FIR little later, my lord. Now, my lord, we can resume on some other day, if your lordship so pleases. Virtually facts are complete, my lord. I'll have to articulate my arguments and place it.
Yes, then we may take some time.
Next, my lord, it will be inconvenient next Thursday, my lord. Thursday, in the second half, my lord.
Next Thursday.
Yes.
22 days, yes. It will not be possible. I'll not be here. Physically going up. Better maybe listed on.
Whenever your lordship sits.
Yes, because these days I'll not be here, in fact.
No problem, my lord. Whenever lordship is convenient.
First week of June, maybe.
Yes. The facts are really longest, my lord. That's why I took some time. Sorry.
It's okay. No, actually, I was ready to hear the matter because these are 2-3 dates most probably were gone.
Yes.
So I thought that anyway, I know that it will take some time. So
Lordship can keep it as, for further hearing.
yes, in that case, further hearing, otherwise, because there are some.
It is part of maybe, because if it goes to another bench,
Huh.
then it will
Again, we have devoted some
Let
time.
it be
Lordship will
before
keep it further or further hearing, we'll leave it to lordship. I think if it is for further hearing also, the hearing remain inconclusive. In that case, it will come here.
But further hearing, yes, either further hearing or part.
Further, as your lordship pleases. We have got nothing to say. Like that, like. No, no, oh, nothing koi apola. My learned friend says, Milan, if I have to start again before another honorable court, then it will again have to spend some. Now at least we are ahead, Milan.
We'll pass the order in that manner that it may be come up at 2 p.m.
Huh.
sharply.
Yes.
Because there are
on a
other
date to be
matters
fixed
that-
by your lordship.
Yeah, yes. That's first we could get the date. 5 Tuesday, Thursday. Thursday.
Oh. Okay. Last time.
5-6 করে দিব order আপনি লিখিব at 2 p.m.
Huh.
At 2 p.m.
Yes, that will
sharply.
be better.
That will be better.
Deeply all right.
Oh. Because Chaudhary, I also felt that instead of hearing the this vacation matter, if the entire matter can be heard, then it will be benefited for you also. So
Yes,
it will be okay. 5-6 at 2 p.m. করে দিব বাকি হার্ড করে দিব টাকাটা সিনিয়র কারেন্ট অ্যাডভোকেট সোয়েন্স ফিল করে দিব ইউ প্রোভাইড ইন এক্সাম
This one last time, 45.
No, not 45. 45 is the last second, yes.
I think 45.
42 fra 44. 42 to 44, same idea but one order will be there. And 45. Yes, this is a case of that.
Cancer patient, my lord, where I file in this for extension, but then my lord, probably he's lucky enough, my lord. There is that section 50, there is no ground, my lord. So this that cancer patient where your lordship was pleased to grant him bail.
Yes. That was
Yes.
extended also.
That was extended also, and then subsequently when all this judgment came, I realized that even in this case, there is no, and therefore I have filed an additional affidavit and brought that on record. That's my. That man, even today also he appeared, my lord, before the lower court. He came, he appeared today, he took a certified copy of the last order because the court below is of the opinion that every date you will have to furnish the certified copy. He has furnished the certified copy. I filed an interlocutory application, this additional affidavit which is on record, running page number 32 is the arrest memo. I have given them a copy, I filed it long back, my lord. On 34/2025, I filed it. Additional affidavit, page number 31.
But most probably you are going to submit on the other issues also. Other issues means on the merits or other issues, anything. Now, this was a case wherein petitioner was granted interim bail considering exclusively his health
Cancer.
He's a cancer patient. Apart that apart, it was extending. So now Mr. Biswas has come with a new issue that the non-furnishing only. In that aspect, you want to submit anything?
Lordship, my humble submission is that this is IA Lordship. And they are get to regular bail application in this case, Lordship.
Yes, obviously.
Lordship may ask.
I is for what? Extension or not?
IA is for I filed a regular bail application. In that the connected case is a case for regular bail application. In that regular bail application, your lordship was pleased to grant me a temporary bail for a temporary period. Now, since my lord, because he was again undergoing treatment in Bombay and everything, I filed an IA for extension of that. Now this ground has come, my lord. So my prayer
So
would
now
be.
she is rightly submitted that in IA that the grounds of arrest may not be heard in IA. So it is connected with the bail application most probably 2427. Is there any separate date there? No, I think.
No, that is disposed of.
11/12/2024, Lordship.
How? Why disposed of?
I'll clarify that, my lord.
No, if it is interim is there, why? How it is disposed?
No, it is disposed of. She's correct. I'll clarify.
And
When the bail application came for final consideration before your lordship said, fine, I'm granting him bail, but for a limited period.
Yes.
And accordingly, 3 months, bail was granted for 3 months and the petition was disposed of. It was not pending. Yes. The petition was disposed of with that direction.
Oh, that is the issue, na? It should not be disposed of. In fact,
Anyways, my
Mm.
lord, it was disposed of. Therefore, I filed a IA during that time period, my lord. Those grounds of arrest and those things were not that much popular, I would say. It was there in the constitution, but it was not very popular. Now, after all these things, your lordship, when I filed an IA, again, your lordship has extended that. And during during the pendency of the IA, my lord,
how it is? Yes, I know, these are the, now you have that ground, but
that
it
ground
was,
of, the ground of arrest, I have bought.
that was, that should not be disposed of, in fact. That
exactly.
was
It should have been kept pending. So
kept
that,
pending, in fact. So somehow it has been disposed of. So on interim, it was disposed of. That should not be, in fact.
true.
It was I have not also, it was
Maybe
out of
it
sight.
happens. It
Out of
happens
sight, it
sometimes.
is gone.
It happens,
Anyway,
absolutely.
then we can do one thing. We cannot go back to that state because it is already disposed of. In terms of that, IA can be disposed of finally,
Absolutely.
which is pending before this court for extension of time. That
Yes.
can be disposed of
Right.
either. Otherwise, the main petition has already been disposed of.
Disposed
Then IA, now the question is in the IA was filed by him only for extension. So in that case, whether you can take those free and all, that is the issue.
I come to that, my lord. My lord, because my lord, a constitutional court can always mold the prayer. And therefore, my lord, invariably in every petition your lordship will see, even in this IA also, my lord, this is an additional affidavit IA. In IA also the prayer is, my lord, though it is the prayer is for extension, but we modification, extension of order dated past in bailable and grant him a regular bail to the applicant in the interest of justice. My prayer is for granting
Your
regular
prayer
bail.
was there.
Yes.
Okay, then if it is a prayer is there, then it's okay.
My lord will see page number 5 of my IA and grant him regular bail to the
Yes, yes, I
applicant.
have seen. So in that case, you want to submit anything. Now the question is that on that day, most probably Mr. Kyle was there and he's submitting that we have to submit something because on the medical grounds or whatever. Now question is that was disposed of. It was not within my thing that it was already been disposed of. I thought that's still pending. Anyway, it is already disposed of. We cannot go back to this. So now he is extending prayer for extension of time. So considering the medical ground and vis-a-vis the ground of non-furnishing the ground of the arrest and all. So these issues, whether you want to submit in that issues because he raised those issue now at present. Now you have filed your additional here.
Absolutely. I filed it way back in 30/4/2025.
Additional.
Additional affidavit annexing the section 50 notice. But in all NCB cases, these are the same format they are using. I have been dealing with those. There is nothing. A2 side of it. नाम लिखना पड़ेगा हरिचरण।
You have annexed only the section 50 only.
Section 50 notice only, madam.
Otherwise, if you want to say that this is obviously, I won't say it is a certified one because there is nothing. It cannot be considered as a certified one. Do you have the certified copy?
No, my lord,
Because it is just photocopy. It is
my
not
lord,
the certified one.
because section 50 notice is served on us. It is served. This is a copy which the accused have in his possession.
Then do one thing, Ms. Kakoti. I also just want to say one thing. If you are in confusion that whether this 50 was there or not, those issues are there because there was an issue that he not only for extension, he prayed for the regular bail also. As you have seen in the petition itself, there was a prayer for regular bail. So we can do at best, we can do one thing. We can call for the scan copy of the LC. It will clarify everything in regards to your section 50 and all. By that time, it may be extended. if you are in confusion, because we are also in confusion because it is not the certified copy. We need the certified copy. Its certified copy is not before us. So at best we can call for the case record. That will do. That will definitely the certified copy will come. Or in the meantime, he will may also furnish the certified copy. If you are in confusion. Yes.
Even, my lord, I will collect the certified copies because these are certified to be true copies by an advocate, my lord. I'll collect the certified copies from the court below because today was the date I'll instruct, and only let them take an instruction. Only an instruction of those lengthy case record probably because I'm not submitting on merit, my lord. So if they take an instruction on the additional affidavit that whether this is a genuine document, only that much instruction probably they will have to take, that whether this is actually
That is your submission. I don't know what is
no,
their submission.
actually this is the section 50 notice or some section 50 notice with grounds of arrest was served upon me, probably because my precise ground is the ground of arrest, which I have taken now, and I've served a copy to them also long back, my lord. By the they could have bought, they have not bought the instruction. I can file the certified copies of this, and in the meantime, let them take an instruction that whether they have furnished the grounds of arrest only to that extent, my lord, because I am not making any submission of merit. So again, my lord, these 600 pages to be scanned in the lower court and again sent to the registry. Again, registry will print 600 pages, tag it. Because my limited submission is, my lord, section 50. Let them take an instruction.
My humble submission is they are seeking regular bail in the IA, and the main bail application has been disposed of. So they can file the regular bail application and they can seek regular bail in that regular bail application. They cannot.
No, but the question is that we are extending.
Lordship.
I mean, there is some, it is out of sight. In fact, the petition was disposed of. It should not be disposed of. I thought it is still pending. I was under impression it is still pending, but now I have seen there is a disposed of, order is of disposed of, but this should not be disposed of on the interim. That there should not be. But now, rightly, wrongly, whatever, it has been disposed of. But the question is that he is now praying for extension of that interim, and which was we are already extending it. Now the question is that in the IA itself, there is a prayer for regular bail. That interim bail can be may be extended, may modified, or it may be regular. So in that regular bail, here, apart from merit, he is not taking the ground of merit. Apart from the other side, is medical ground, he is also taking the ground of non-punishing. Yes. So in that case, I'm just asking you whether the certified copy, if he file on the next day, will you be able to submit on that record or want to submit on merit? If you want to submit on merit, then definitely scan copy may be required or your objection may be there. That's what I'm asking. Because at present, it's what is happening that interim, though what is the interim, that was disposed of. It shouldn't be disposed of. So it was a take, but here the question is that we are extending that interim by IA.
Now
So
they are seeking regular.
yes, regular in a sense in IA itself, there was a prayer from their side that did alteration modification apart from their regular bill prayer, which was earlier granted. So I don't think it's a very thing
Yeah,
that prayer may be made. So in that case, what will be your submission? Certified copy will do or
The certified copies, and we'll file our
certified
objection.
copy?
We'll file our objection in the meantime, and that can be.
Your objection you can file?
Yes.
And what do you want to call for the scan copy also? It's not
was-
required, I think.
If they will.
I'm not submitting on merit. On merit में कुछ बोल ही नहीं रहा.
He is insisting only on the that ground. Because it is an admitted fact that the, most probably the petitioner is a cancer patient. He is taking treatment and
Even a report
that
from
is-
jail
that
was
is
also
there.
called before the first order was passed.
Yes, that was there only. Do we recall for the report from the jail authority? He is a cancer patient. That is admitted.
We'll file our objection, and that can be considered.
Okay. Heard Mr. M. Biswas, the learned counsel for the petitioner. I also heard Mr. T. Jain, the K. Jain, the learned counsel appearing on behalf of Mr. S. C. Kyle, the learned standing counsel NCB. Next paragraph, Mr. Biswas submitted in this regard that in the through the instant interlocutory application, he is praying for extension of the interim order, bail order granted to the present petitioner, along with the prayer for modification and the regular bail. Further, Mr. Biswas submitted that he also raised he has already filed his additional affidavit, raising the issue of non-furnishing of the ground of arrest in notice under section 50 CRPC. Stop. Mr. Biswas further submitted that the petitioner is still under medical treatment. However, he appeared before the learned trial court below and obtained the certified copies of the order. In that context, Mr. Jain, the learned counsel for the respondent NCB, submitted that they will file the written objection in that regard, and Mr. Biswas is also hereby asked to file the certified copy of the notice and other documents, if any, on or before the next date of listing. Till then, the interim bail granted to the petitioner order date is 11/12/2024 will be extended till next date of listing. List accordingly after 2 weeks will be after 2 weeks. List after 2 weeks. Okay.
Much of it, sir.
Go ahead. I have my bench from the next week at Kohima, in fact.
Oh, 2 weeks in Kohima.
Maybe extended also. I think.
Weather will be very fun.